Good to go. All right. Good morning. It is January 29th. This is the morning calendar for the Olympia Municipal Court, Yelm Municipal Court. My name is Judge Pro Tem Chris Coker. First matter we have is City of Yelm versus Jeffrey Pruitt. This is cause number 4A0771324. Comes on for compliance on a deferred prosecution. Mr. Pruitt is present. Mr. Ratfield is present for the city. So Mr. Pruitt, my notes indicate you've been on deferred prosecution since maybe 2024. You entered this in March of 2025, and we have a report that you are no longer in treatment. Is that correct?
Yeah, I moved to coma, so it's kind of been a miscommunication between me and the treatment.
Okay. So are you going to get back into treatment?
Yeah, I tried to call my old counselor, kind of see what steps I would need to take, because I did like complete most of the bulk of it.
Yeah, you did. You did probably the heavy lifting of it.
Yeah, and then I ended up moving to coma and wasn't really having any luck trying to find somewhere that would accept my insurance.
Okay.
I can't afford to pay out of pocket, so might have to go maybe back to the AC or something if I need.
Okay. The letter we have that you've been out of treatment since September 8th of 2025. So obviously with the deferred prosecution, the rules are pretty stringent. I see that the city gave you a bit of a break because it looks like you got a driving issue after the fact, which is okay. I mean, again, that's up to the city in that situation. You're revoked third degree right now. Okay. I guess what's the city's preference on this?
The city's willing to give you some more time, but considering he's getting to license and get cities, you have any time to make that decision? Do you have a time frame of when you make
the decision? I've been driving me around, so right, well, I'm going to the area.
Well, I'll tell you what we're going to do. So I'm going to continue this out 60 days, and we're going to give you 60 days to get back in treatment. One of two things is going to happen at that next hearing. If you're in treatment and you get proof to the court, we can strike the hearing and you don't have to show up. If you're not in treatment, I'm going to expect the city to revoke the deferred prosecution. And if that happens, well, it looks like this would be a first offense unless there's an out of state somewhere. But I think the city would have no choice but to revoke the deferred prosecution at that time. Okay. So you got 60 days to get this squared away. Okay. No, you got to be back into treatment because the program's 5 years. The treatment aspect of a deferred is a minimum of 2 years, right? And then you're on probation for 3 years. So if you're treatment, all this is doing is extending the 5 years. So if you're in treatment, if it takes you 4 years to complete your treatment, then it's 3 years on top of that. So then you're on probation 6 years. If it takes you 4 years, 5 years, 6 years, add 3 to that. So all you're doing is extending the jurisdiction this court has. So it's beneficial for you to get your treatment done sooner than later. So, but no, we're going to kick it out 60 days. If you're back into treatment on the deferred, whether it's at Northwest or somewhere else, get proof to the court. If we have that, we can strike the hearing. If not, I'm assuming the city will revoke the deferred and we'll just move forward with that.
Once I get into those facts, we're ready to come in.
No. You just get it you contact the clerk, and I just need to make sure you get the treatment proof here. Okay. Okay. Do I need to sign anything for that? Okay. Next court date is going to be March 26th at 8:15. And provide proof back in treatment compliance. If proof on file, the hearing can be canceled. All right. I've signed that order. We'll grab a copy of the window and good luck. Okay. Hopefully I won't see you in 60 days. Okay. Yep. Take care. All right. I think were you here? What are you here for court? Okay. What's your name? Or what are you here for court? What time? Okay, and in the front, are you here for court? No. Mrs. Wing. Okay. Okay. Let's go ahead and pull them up. All right, Mr. Ferguson online, can you unmute yourself and pull your camera up, please?
Okay,
I can hear you. Can you turn your camera on?
it's not on either. Here we go. It's just being slow, I think.
There we go. Thank you. All right. Good morning, Mr. Ferguson. This is cause number
Morning.
580312333 and 580448989. Mr. Ferguson is present via Zoom. Mr. Ratfield here for the city. We are here on a compliance issue. These are both DUIs from 2025. We are missing some treatment reports for August through December. Yeah, we're missing treatment reports for the DUIs. What's going on?
Yeah, so I did get back in. So when I moved out here to Ohio, I was denied the state medical. So I had to wait until I got employed. And then once I got employed, I had to wait the 30 days for my medical to kick in. And then, yeah, I am in it's called Brightview. They should have sent you information. They were supposed to send it over to you at the beginning of this week.
Everything from? Okay, we don't have anything from them.
Okay.
So you want to definitely call them. And also the way, so you started the deferred, and there's no issue with doing a deferred treatment program out of state. But Mr. Ferguson, what the treatment provider outside of Washington needs to do is you need to give them a copy of they need to know what our state requirements are for treatment.
Okay.
And just kind of follow that. And so they should know that, I would imagine.
Yeah.
But the main thing is you need to just make sure they get us something. So, but you're
Yeah,
telling.
they should be sending that over. I did. I'm sorry. Go ahead.
We're actively back in treatment now?
Yes.
Okay. Why don't we do this? I believe you, Mr. Ferguson. What we're gonna do is we're gonna continue this hearing 30 days to
Okay.
enable you to get your new treatment provider to provide proof of treatment to the court. If they
Okay.
do that, we can strike the hearing and you don't need to appear. If we don't have it, at that time, we'll just move forward with which the other option is revocation, which I don't think the city really wants to do. So, but it sounds like you just need to get the wires lined up so that they get treatment, they get the proof here.
Yeah. All right. Yeah, they should have sent. I'll get a hold of them. I did sign the release of information and all that, and gave them all the information for the court and the email and the fax number and all that. So I'll get it squared away.
Okay, thank you. And we're going to set this for February 26th at 8:15. You'll be authorized to appear via Zoom. The order does note that if you provide proof that you're back in treatment compliant, and if that is on file with the court, the hearing can be canceled. Okay?
All righty. Thank you.
Mr. Ferguson, we'll email you a copy of this, okay?
Yeah. Thank you.
Yep, thank you. Good luck to you.
All right. You too. Bye.
Bye-bye. Next one I'm going to call is City versus Timothy Higgins. Mr. Higgins present? Nope. Okay, it is 8:15 calendar. This was a sentence compliant reckless endangerment. I reviewed Mr. Higgins. This is cause number 2A01176669. Mr. Higgins provided some materials to the court regarding treatment compliance that the clerk's office followed up on with Northwest Surety or Northwest Resources too, and there is a significant issue regarding the validity of these documents. So also at the last hearing, Mr. Higgins was directed to be here in person. Zoom was not authorized. He's not here. It's a little bit after 8:30. Again, this is a treatment. He has provided no treatment for years. He's not here. Does the city have any opinion on Mr. Higgins?
Yeah, so you would like to see,
Okay, $2,500 cash or bond on Mr. Higgins, please. And then next matter on the 815 is City versus Tony Sen, 5A0203263. Is there a Tony Sen present? Hearing no response, Mr. Sen was here for a violation of post disposition on operating motor vehicle without ignition interlock. And Mr. Sen looks like he got another got several violations of not having the interlock. What's the city's preference?
so you'd like to see more.
Okay. I'll go 1,000. Yeah, 1,000 cash or bond, please, on Mr. Sen. Next matter is Anna Taro. Cause number 4A0896720. This is a criminal trespass first degree. It's a SOC review. And lo and behold, Ms. Taro is in compliance, but hasn't paid the $250. What's the city's preference?
City would, let's see.
Okay. We will go 500 cash or bond on Ms. Taro. If she comes in and pays the $250, the warrant could be quashed and the case can be closed.
Yes.
Okay. All right. And last but not least, Esperanza Venegas. Cause number 4A0826182, compliance diversion. This is another SOC. Charge of theft, third degree. In compliance other than, looks like the no 250.
So you'd like to see this reset with notice.
Okay, so no warrant. We'll note the non-appearance for today's purpose. We'll reset it out 30 days. If the 250 is paid, obviously it's stricken. Okay. All right. Okay. And then you folks have private counsel? Okay, great. Appreciate you being early. I just can't do anything until your lawyers get here, so. Mr. Ratfield, is the bench trial at noon going to go? Okay. Come on forward. Good morning. Which case are you here for?
Your Honor, I've got two and and let me make sure I've got the right name because I'm covering for a new.
Okay,
Christopher Robinson.
okay.
Yep, that's correct, Judge. Thank you.
48003.
On the 9 o'clock.
Yes.
All right, ready? This is cause number 480035381. City of Yelm versus Christopher Carl Robinson. Council present, what's your name?
Good morning, Your Honor. Joshua Rosen, covering for the attorney of record in this matter.
Okay, what are we doing today with Mr. Robinson's case?
There's a motion to continue that was filed in Oak Courts. Mr. Robinson is currently in custody pending an attempted murder case in another jurisdiction, which is the basis for the motion.
Okay. Any objection from the city? All right, I see the motion to continue. The request is to reset this to February 26th at 9 a.m. No objection from the city, so we'll go ahead and grant the order. And I'll sign the order.
Thank you, Judge. And I had one other matter, but my client's going to be here in person and it's a little bit, it's on the docket later this morning. So I'll see.
Okay,
See you in a
all
little
right.
bit.
Go ahead and sit tight and we'll call you back when you're ready to go.
Okay, yeah, thank you. Good morning, the court, and good morning to the city.
Yep. Will we take the Sanchez matter? Is that what I heard?
Well, yes, sir, the intention though is to amend this to a civil action.
So I've got, is this Julia, is it gonna be Julia Sanchez?
Yes, sir.
So this is City of Yelm versus Julia Sanchez, cause number 580-557-606. Mr. Sanchez is present with counsel. Mr. Van Vechten?
Yes, sir.
That's right. So I have got in Oak Courts, looks like somebody loaded up a infraction disposition form. Is the city taking a look at that or is
Yeah, city's looking at it now.
that gonna work? Madam Clerk, how will we do this? Looks like it's gonna be amended to an infraction.
Yes, so.
This is first.
Do you know the RC or the local code?
I sent it.
Yeah,
Okay. If we can just give that to the clerk, that would be helpful.
Yelm Municipal Code 944-010.
And that'd be $150. Okay.
Fee schedule, sir.
Understood. Okay, $150. The theft third is amended to nuisance under 9.44010. Anything else on this matter?
No, Your Honor.
Appreciate it, sir.
that correct, Mr. Sanchez? All right, okay, all right, I've signed that order. You can get a copy of the window and set up payments. Thank you. Is that all you have? Okay. Any sign of the jail? Okay. Why don't we take the private case, which is, you said Attorney Kale for what case? Is that a, it's a what? Okay. Mr. Ratfield, on the Cynthia Lobo Hernandez case, number 8 on the docket, is there gonna be, what's the intention today? Do we know?
Lobo Hernandez. Yeah, we're continuing the matter.
Okay. All right, let's call that one. Good morning, Mr. Hale. This is City of Yelm versus Cynthia Lobo Hernandez, cause number 5A06992750. Is Mr. Hernandez, Lobo Hernandez present, or are you appearing on her behalf?
I'm here under 3-4 Your Honor. Good morning, Matt Hale appearing from Ms. Lobo Hernandez. I have been emailing Garrett about this, so we're negotiating it actively. I'd like to set it over one last time to try to work out a deal. And I did get discovery, so we have everything we need.
Okay. All right. Request is to continue this to February 26th, 9 a.m. Any objection from the city?
No, Your Honor.
Okay. All right. I'll go ahead and grant the continuance. This is a case from August. I'd like to see it moving forward. So this will be the last continuance. So hopefully we'll get it resolved on the 26th.
Sure, Your Honor. Sounds good. Thank you.
Okay.
Have a good rest of your
In
day.
that order. Thank you.
Thank you.
Okay. All right. Mr. Haverco in the jail. Are you ready to go?
I am, Your Honor. I will go retrieve, give me a second here. Flip back in the calendar here. I will go retrieve Mr. Heitzman. Mr. Heitzman?
Last continuance. I put that it was granted. Does that matter? I didn't, but
Perfect.
I signed it. All right. Good morning, Mr. Heitzman. This is cause number 5A072834. You are present in custody with Mr. Haverco. What are we doing with Mr. Heitzman today?
I have gone over the case with him. We've discussed it. I placed a statement of defendant on plea of guilty in O courts. And we're ready to proceed with a plea as indicated in the form.
All right. Thank you. You are Michael Douglas Heitzman.
Yes, sir.
All right, Mr. Heitzman, I have before me a statement of defendant on plea of guilty to a charge, originally a controlled substance knowing possession violation. Looks like it's an amended. There's a theft third charge as well, but then the controlled substance knowing possession will be amended to an unlawful use of drug paraphernalia.
Correct.
Yes, Your Honor.
Thank you. All right. And did you have enough time to go over this with Mr. Haverco?
Yes, sir. Yes, sir. Yes, I did.
Did he read it to you, or do you read it to yourself, or a little bit of both?
Both of them, Your Honor.
And what's your last level of education, Mr.?
I have an AA degree in math.
Okay.
I'm completely worthless, but I still got it.
Okay. What I will do is put 12 plus.
Thank you, Your Honor.
Thank you. All right. So you understand on this, there's a number of constitutional rights contained at paragraph 5. You understand you're giving up those rights by pleading guilty?
Yes, Your Honor.
And Mr. Haverco, did you discuss any potential immigration issues?
I did, and I don't believe there are any of those issues in this case.
All right. Maximum penalty on theft third is 364 days in jail with a $5,000 fine. Maximum penalty on unlawful use of drug paraphernalia is 90 days in jail with a $1,000 fine. You understand, Mr. Heitzman? There's
Yes, Your Honor.
recommendation in here. I could sentence you up to the maximum.
Yes, I understand, Your Honor.
Okay. All right. Paragraph 11 states on December 2nd, 2025 in the city of Yelm, I stole merchandise. While being searched by the police for the theft pursuant to being arrested, it was discovered that I knowingly and unlawfully possessed a pipe I had recently used and was for the purpose of smoking and consuming a controlled substance. Are those your statements?
Yes, Your Honor.
So as to the charge of theft third degree, how do you plead? Guilty or not?
Guilty.
As to the charge of unlawful possession of drug paraphernalia, how do you plead? Guilty or not guilty?
Guilty.
Okay, I'll find you both your pleas were made knowingly and voluntarily, and you weren't, no promises were made to cause you to enter the plea other than what's set forth in the statement. Mr. Havercore, are we moving forward to sentencing today?
We are, and I believe the city is recommending time served. That's what we would ask for. And I also asked based on indigency status, I would ask the court not to impose any financial obligations.
Okay. All right, Mr. Ratfield, anything additional?
Nothing else, Your Honor.
All right, Mr. Heitzman, anything you'd like me to consider before sentencing?
No, Your Honor, thank you.
All right, on the theft third, I will impose 364 days in jail with 364 days suspended. How many days credit do we think he has?
How many days have you been in jail?
Since the first of the year. So.
He's been, have you been in jail since the first?
Yeah, New Year's Day I got arrested.
So he's been in jail since the first. 'Cause I think what happened was that he came up for an arraignment and the court didn't release him on his own recognizance, so he's been sitting. So I think he probably has at least 28 days.
28, 29 days, yes, sir.
29 days.
Is that right? Can you tell me? He's being held on other things, so he has 4 days credit for us.
Okay.
So what I'll do is I'll impose 364, we'll suspend 360, give you credit for 4 days. So won't be an additional jail time on that. $5,000 fine, I'll suspend all $5,000 for a jurisdiction will be for 12 months. Where'd this incident occur? Where did the theft occur?
Walmart and Yelm.
Okay, no, you're to have no contact with the Walmart in Yelm. On the unlawful use of drug paraphernalia, I'm going to impose 90 days in jail, going to suspend 90 days for a period of 12 months. Based on your indigency status, I won't impose any fines. Conditions are going to be law-abiding behavior. Don't go back to Walmart. Appear timely at all court hearings. You understand that?
Yes, Your Honor.
All righty, I'll sign this order. Good luck to you.
Thank you, sir.
Thank you, Your Honor.
Thank you.
Look at it.
Yeah.
Your Honor, we have another 9 o'clock matter.
Okay, give us 1 second. Let me take this next one, then we'll do your next. Okay. All right, who do we have here, Mr.?
This is Kevin Jones, Your Honor, and he comes before the court. 1, 2, 3 on 4 matters, and I've gone over a plea statement with him. We've got some charges that he's pleading to, and then some that are being dismissed. So on the 937 matter, dismiss, 938 plea, 378 a plea, and then on the 291, it's dismiss the count 1 controlled substance, plea to the paraphernalia.
Okay, all right. All right, good morning. You are Kevin Jones?
Yes, sir.
All right, good morning, Mr. Jones. What's your last level of education completed?
12.
Got a statement to defend on plea of guilty before me. Did you read through this plea agreement, or did Mr. Haverco read it to you, or a little bit of both?
Both.
Okay. Feel like you've had enough time with Mr. Haverco for him to answer all your questions and things like that?
Yes, sir.
Okay. So per this plea agreement, you're going to be entering a plea of guilty to cause number 5A0627938, which is criminal trespass second degree. Plea of guilty to 5A0886378, which is reckless burning second degree. And a plea of guilty to 6A002429, which is count 2 of that particular cause number for use of drug paraphernalia. If those pleas are accepted, the city will be moving to dismiss 5A0627937 which is a criminal trespass second degree, as well as 6A00242291, which is a controlled substance knowing possession. Is that your general understanding of what's you think is going to happen today?
Yes, sir.
All right. Criminal trespass has a mandatory or a maximum penalty of 90 days in jail with a $1,000 fine. Reckless burning, each of those counts. Reckless burning has a maximum penalty of 364 days in jail with a $5,000 fine. And the use of drug paraphernalia is 90 days in jail with a $1,000 fine. You understand that there is a recommendation contained in this plea agreement that I don't necessarily have to follow. I could sentence you up to the maximum.
Yes, sir.
And and did you discuss any potential immigration issues with Mr. Jones? Mr. Evans?
We did discuss it, and there are no immigration issues.
Thank you. All right, Mr. Jones, paragraph 11 will contain a statement. I'm going to read that statement. It says the following occurred in the city of Yelm on October 19th, 2025. On that date, you entered Timberland Library property in violation of a no trespass notice. On November 3rd of 2025, I knowingly started a fire under a bridge outdoors, which under the circumstances create a reasonable risk of causing damage to surrounding structures or property. And then on January 10th, 2026, I possessed a tinfoil and a straw I'd recently used and for the purpose of consuming controlled substances. Are those your statements?
Yes, sir.
All right. So as to the charge of criminal trespass on October 19th, as to that charge, how do you plead, guilty or not guilty?
Guilty.
As to the charge of reckless burning second degree alleged to have occurred on November 3rd, 2025, how do you plead, guilty or not guilty?
Guilty.
And as to the charge of possession of drug paraphernalia on or about January 10th, 2026, how do you plead, guilty or not guilty?
Guilty.
All right, I'll find your pleas are made knowingly and voluntarily. No one's made any threats or any promises of any kind to get you to enter the plea. Hear from the city in terms of sentencing.
Your Honor, it's
All right. Mr. Haverko.
That's a recommendation, Your Honor. Time served. He's been in custody at least since the last court date. So he's been in custody at least 2 weeks, and he may have been in custody a few days before that. I don't recall.
No, just the past 2 weeks.
How many days credit does he have? Okay. So he's got 19 days credit. All right, Mr. Jones, anything you'd like me to consider before sentencing?
No.
All right. So, Mr. Jones, you've been in since the, you said the 10th? And I'm looking at your criminal history, and you've got, going back to 2019, we probably have a dozen and a half similar charges. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. I have at least a dozen criminal trespasses. Actually, I have probably 15 to 20 criminal trespasses. So how are we going to stop you from going to places you're not supposed to go? Mr. Jones?
I had that they were dismissed.
Say again?
I had they were dismissed.
Did you? I see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. I have at least
And
15.
I've been having trouble with my paperwork. Somebody keeps stealing it. Somebody keeps stealing my paperwork.
Okay, so that's what is preventing you from staying away, for example, the Timberland Library?
Yes, sir.
All right. Okay, what I'm going to do is this. I'm going to modify the sentence just a little bit. Mr. Jones, I'm going to do this. You've got 19 days credit. I'm going to, on the criminal trespass second degree, I'm going to give you 90 days in jail. I'm going to suspend 60 days for a total of 30 days. Give him credit for 19. You'll have to do 11 more days on that charge. I'm gonna impose $1,000 fine, gonna suspend all 1,000 on that for a period of 12 months. Reckless burning, I'm gonna impose 364 days in jail. I'm gonna suspend all 364. Gonna impose $5,000 fine, suspend all $5,000 for a period of 12 months. And on the use of drug paraphernalia, I'm gonna impose 90 days in jail. Gonna suspend all 90 for and then impose $1,000, suspend $1,000 for a period of 12 months. Not to have any contact or go on the property of the Timberland Library. Do you understand that?
Yeah.
Okay. If you go back to the Timberland Library, I guarantee you, I will sentence you to all of the remainder of the time. Do you understand that?
Sure.
Do you? Okay. Well, we'll see. Because these sort of violations of this type need to stop. And one way we get them to stop is we hold you in jail. So hoping we don't have to continue to do that. But also we're not gonna put up with this any longer. I just want to make sure you're on notice of that. So that'll be the sentence. I wish you luck, Mr. Jones. You'll serve the remainder of the 11 days in custody. When you're released, I hope you go get the services you need and you move forward. All right?
Yeah.
Good luck to you. Okay. Mr. Haverco, we're going to sneak in one private.
Okay.
Quickly. So I'm going to sign the order on Jones. All right. Who do we have here?
Good morning again, Your Honor. This is the case of Elizabeth Pappas.
On the 9 o'clock?
That's the 9 o'clock, yes, Judge.
All right. What are we doing with Miss Pappas today?
So again, Joshua Rosen on behalf of my client, Ms. Pappas, who's here in person. A fairly new case, Judge. The motion to continue has been filed really to allow us to do a little bit of pretrial posture negotiations or trial preparations if that was something that's needed.
All right. Good morning, Miss Pappas. This is cause number 5A07-54726. Ms. Pappas is present with counsel. Have a motion to continue. Any objection from the city?
No.
Okay. All right. We're going to reset this matter to March 26th at 9 a.m. The waiver commencement date of that date. Expiration date of June 24th. Ms. Pappas, stay in touch with your attorney. We'll give you a copy of this order and we'll see you back here on March 26th. All right. That's all. Anything else?
No, thank you. Good morning, Your Honor. Good morning to the city.
Thank you. Have a good rest of your day. Okay. Thank you, Mr. Haverco.
You bet. Thank you. So this would be Joshua Patterson. Matter comes on for a pretrial hearing. I've gone over a plea statement with him. It's in O courts and we're ready to proceed.
All right, thank you. All right, good morning. You're Joshua Patterson?
Yes,
All
yes,
right,
sir.
good morning, Mr. Patterson. This is cause number 5A0150683. Mr. Patterson's present in custody with counsel, and let me get into this. Okay, got a proposed guilty plea. Mr. Patterson, what was your last level of education completed? Highest level?
Yeah, high school.
Okay. Okay, the charge in this case is theft third. The intent looks like if the theft third plea is accepted, the city would move to dismiss the criminal trespass first degree. Did you read through this document, Mr. Patterson, or did Mr. Haverco read it to you, or both?
Both.
Okay. Feel like you've had enough time with Mr. Haverco for him to answer all your questions?
Yes, you're right.
Okay. So, and any paragraph 5 talks about a number of constitutional rights that you're giving up by pleading guilty. Do you understand you're giving up those rights?
Yes, Your Honor.
And Mr. Haverco, have you had a chance to talk to Mr. Patterson about any potential immigration issues?
I have, Your Honor, and there are no such issues.
Great. All right, Mr. Patterson, maximum penalty on a theft third is 364 days in jail with a $5,000 fine. You understand there's a recommendation contained in this plea form. I don't necessarily have to follow. I could sentence you up to the maximum.
Yes.
Okay. And paragraph 11 states, on January 26th, 2025, in the city of Yelm, I stole merchandise from Walmart. Is that your statement?
Yes,
So as to the charge of theft third degree, how do you plead, guilty or not guilty?
guilty.
Okay. Find your plea is made knowingly and voluntarily. No one's made any threats or promises of any kind to get you to enter the plea. And city's motion to dismiss the criminal trespass first degree charge is granted. Anything from the city on the recommendation for sentence? Okay, Mr. Haverko.
Just asking the court to follow the time served recommendation and not impose any financial obligations.
Okay, Mr. Patterson, anything you'd like to say before sentencing?
That's about it.
All right, Mr. I'm just going to look up something real quickly. So, Mr. Patterson, you don't have a ton of thefts on your history. You've got a few. You've got one that's pending in Lacey, it looks like. This case is from these all happened. I mean, actually, you got one from Lacey in September, which may have just been charged, but then you had a series of thefts. The flurry, you've got other ones pending in Thurston County. So are we going to be able to stop this process? Because you don't have a ton of history.
Yeah, like I'm new in town and made homeless. Just
Okay.
More
All right.
resources and
I just want to make sure you understand. I mean, you obviously got held. You're going to have some, I'm going to follow the recommendation in this case. And there's a warrant that'll be quashed. Okay. But the conditions of your sentence are going to be, I'm going to impose 364 days in jail. How many days credit do you have? 3? Okay. So 2 days credit. Okay. Going to give you, you got pulled. I got you. You got taken in on the warrant. Okay. Going to give you 2 days credit. You're not to go back to Walmart. You're not to have any criminal law violations. And those are pretty, I'll impose the fine amount, but I'll suspend the entirety of the fine amount based on your indigency. But don't go back to Walmart and don't steal.
yes,
Pretty
sir.
simple. Got it?
Yes.
All right. I'll sign that order. And again, I gave him 2 days credit, so you won't have any more jail time on that. And again, the sentence is effective for 12 months. So if you violate any of those conditions, you can be brought back and sentenced to all a portion of that time. All right, Mr. Patterson, I've signed the order. Good luck to you. All right.
Your Honor. Thank you.
This is Adrian Roberts on his DCH. There's a different name, last name of Sena. I guess at some point there was a name change, just for the court's information. But this comes on before the court for an arraignment. We want to go ahead and just proceed with arraignment. I'm assuming he wants counsel, and I believe he qualifies.
Okay. All right. Good morning. Is it Datrion Roberts?
Yeah.
Okay. So Mr. Haverko, I've got him listed as Datrion Roberts with a date of birth of 7/4/1990. Is that correct?
Yes, sir.
Yeah.
Okay. Cause number 6A0006653. Mr. Roberts is present with counsel in custody, on for arraignment. Mr. Haverko, do you do any inquiry as to his eligibility for court-appointed counsel?
He is indigent. He's not employed, kind of homeless. So I do believe he does qualify for court-appointed counsel.
Okay. All right. I'll turn it over to you, sir.
Thank you, Your Honor. Stipulate to probable cause and ask the court to enter not guilty plea, and then we'd just like to discuss release conditions.
Okay. So Mr. Roberts, based on the statements of counsel, I'm going to waive further reading of rights. I'm going to find probable cause for purposes of this hearing only, and I'm going to enter a plea of not guilty to 1 count of possession of a dangerous knives and 1 count of controlled substance knowing possession. So I'll hear from the city as it relates to release conditions.
Your Honor, it's
Can't hear him.
PR.
Okay.
Recommendations for a PR release. Mr. Haverko.
Would agree with that.
Okay. All right. So Mr. Roberts, I'm just looking at your history here. What I'm gonna do is I'm gonna release you on your own recognizance under the following conditions. You're not to commit any criminal law or criminal traffic violations. I'm gonna appoint Mr. Haverko moving forward. You're to appear timely at all court hearings, and basically maintain law-abiding behavior while these cases are pending. And I'm gonna also advise, you're gonna be ordered not to possess any dangerous weapons during the period of pretrial. Do you understand those conditions?
Yep.
All right. Okay, so we'll give him an out of custody date for pretrial with Mr. Haverko. Next court date, Mr. Roberts, is going to be March 26th at 11 a.m. Stay in touch with Mr. Haverko. You'll be given a copy of this order, and make sure Mr. Haverko has a good number for you, okay? All right. Thank you, Mr. Roberts. Good luck.
Thank you, Your Honor. John? See? This is John. How do you say your last name?
Bailey.
Oh, this is John Staley. He has a couple of cases on. There's a little bit different spelling from one to the other. It's the same individual, and I've gone over a plea statement with him and placed it in all courts, and I anticipate he's on the new case. He's going to plead to the excuse me, the theft third, the use of drug paraphernalia, and then upon the court's acceptance of the plea as part of the agreement, the city would move to dismiss count 3, the controlled substance violation, and also the older theft, the old 1A case that occurred back in May of 2021. That's to be dismissed.
All right. Is it, well, how do I pronounce your last name, Mr.? Is it Stolly?
Oh,
It's Staley, Your Honor. Staley.
All right.
Staley.
All right. Good morning, Mr. Staley. You're here for a couple matters. One matter is 1A0443173. Second matter is 6A0061882. Mr. Staley is present in custody with counsel. Mr. Staley, what's your highest level of education completed?
I went to college a couple years.
Okay. All right. And I have before me a statement of defendant on plea of guilty. Did you read through this document with Mr. Haverko, or did he read it to you?
I read it to you. He read it to me, Your Honor.
Okay. Feel like you've had enough time with Mr. Haverko for him to answer all your questions?
Yes, sir.
All righty. Paragraph 5 of this document contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand that?
Yes, sir.
And Mr. Haverko, any immigration-related issues, or did you, I don't need to know if there are. I guess I just need to know if you discussed those with potential issues with him.
I did, Your Honor.
Thank you. All right. And Mr. Staley, you understand there's a number of charges here. Theft third degree is one of them. The maximum penalty on that is 364 days in jail and a $5,000 fine. On the use of drug paraphernalia, the maximum penalty is 90 days in jail with a $1,000 fine. You understand that there's a recommendation contained in here that I don't have to follow. I could sentence you to the maximum.
Yes, sir. I understand.
Okay. All right, Mr. Staley, as to paragraph 11, it states on January 11th, 2026 in the city of Yelm, I stole over $300 worth of groceries from Walmart. During my subsequent arrest for the theft, I was in possession of paraphernalia I'd recently used and was for the purpose of consuming cocaine, a controlled substance. Are those your statements?
Yes.
But as to the charge of theft third degree, on January 11th, how do you plead? Guilty or not guilty?
Guilty.
And as to the charge of possession of drug paraphernalia on the same date, how do you plead? Guilty or not guilty?
Guilty.
Okay, I'll find those pleas are made knowingly and voluntarily. No one's made any threats of harm or any promises to cause you to enter the plea. And with that, I'll grant the city's motion to dismiss the controlled substance knowing possession violation. Hear from the city in terms of sentencing.
Your Honor.
Okay. Mr. Haverko.
It's an agreed recommendation, Your Honor, credit for time served, ask the court not to impose any financial obligations.
All right, Mr. Staley, anything you'd like me to say or anything you'd like me to consider before sentencing?
Well, thank you for the time, Your Honor, to think it over, and I can change a few things in my life, and thank you for the time.
Okay. All right, and Mr. Haverko, if we know, what was the status of the $300 plus in groceries that were
I
stolen?
think they were retrieved.
Yeah,
Yeah, they were retrieved. He was apprehended and the store got them.
actually, I gave the basket back.
How many days credit does Mr. Staley have? Staley? Okay, on our charge? Okay. All right, Mr. Staley, I'm gonna follow the recommendation. You've been in since the 11th of January, so you've got about 18 days credit. So I'm gonna impose 360 on the theft charge. I'm gonna impose 364 days in jail. Suspend 354 or 346. Okay, 340. I'm gonna suspend 346 days, which will remain suspended for a period of 12 months. Conditions are going to be, you're not to go back to Walmart. You're not to have any criminal law violations. You're to make all court hearings and maintain law-abiding behavior. Do you understand those conditions?
Sir,
Okay. I will also note you have a warrant out of Thurston County that you might want to get straight taken care of. It's from January of last year. So, and there's another one out of, looks like Puyallup Muni or Port Orchard Municipal. So just so you know, I see a warrant out of Port Orchard and a warrant out of Thurston County.
sir, I'll endeavor to do that.
It just would make sense for you to do it. So I'm just letting you know. Okay. All right. I'll sign this order. Mr. Staley, good luck, or Staley, good luck to you. Okay.
Thank you, Your Honor.
Thank you, sir.
Go ahead, see.
Did I leave these papers?
No, those are mine. Just have some. Yes. Brandon? Wait. Oh, are you reading this page?
I think so. I think I was.
This is Brandon Wing, Your Honor.
All right. Good morning, Mr. Wing.
Morning.
You're 5A, you're here on a number of matters, 5A 06279399, 416, 579, 650, and 690. Okay. All right, Mr. Wing is present in custody with Mr. Haverko. What are we doing with Mr. Wing's cases today?
Well, we prepared a statement of intent of plea of guilty, which I reviewed with him, and he's pleading to some and dismissing some, and so I anticipate it's indicated in the form. So he's pleading guilty to, looks like one of the trespasses, 939, and then on the criminal trespass first, a plea to that, but amended to the lesser charge of criminal trespass second. Then also the other trespass on 1/4/26 and ending in 650. The other counts to be dismissed.
All right. All right, Mr. Wing. Mr. Wing, what was your highest level of education completed?
I dropped out in 10th grade.
Okay. Get your GED?
No, sir.
All right, Mr. Wing. I've got a number of charges here. It looks like your intent is to plead guilty to a charge of criminal trespass, second degree, 6A0006650. Plead guilty to another criminal trespass under 5A06279939, and a criminal trespass first degree is amended to a criminal trespass second degree under cause number 5A06577416. In exchange, the city is going to be making a motion to dismiss 6A0015690 and 5A0864579.
Right.
Mr. Wing, have you had the opportunity to read through this document, or did Mr. Haverko read it to you, or both?
Both.
Okay. Feel like you've had enough time with Mr. Haverko for him to answer all your questions?
Yes, sir.
Okay. And Mr. Haverko, have you had a chance to discuss any potential immigration issues with Mr. Wing?
Yes, I have.
All right. And Mr. Wing, you understand that there are, these are misdemeanors, means maximum penalty on each criminal trespass is 90 days in jail with a $1,000 fine. You understand that there's a recommendation contained in this plea agreement, but I don't have to follow that recommendation. I can sentence you up to the maximum.
Yes, sir.
Okay. Paragraph 11 states, on November 8th, 2025, you entered Tractor Supply in violation of a no trespass notice. On November 5th, 2025, I entered AMPM property in violation of a no trespass notice. And on January 4th, 2026, I entered Nisqually Plaza property in violation of a previous no trespass notice. As to the charge of criminal trespass involving the Tractor Supply on November 8th, 2025, how do you plead, guilty or not guilty?
Guilty.
As to the no trespass notice violation on November 5th, 2025 involving the AMPM property, how do you plead, guilty or not guilty?
Guilty.
And then finally, January 4th, 2026, I entered Nisqually Plaza property in violation of a previous no trespass notice. How do you plead, guilty or not guilty?
Guilty.
Okay. Find your pleas are made knowingly and voluntarily. No one's made any threats or any promises of any kind to cause you to enter the plea. I'll hear from the city first in terms of sentencing.
Your Honor, it's an agreed recommendation.
Okay. Thank you. Mr. Haverko.
That's it. I couldn't hear the city's recommendation. We can't hear it.
Agreed.
It's an agreed recommendation.
Yeah, it's agreed.
All right. Mr. Wing, anything you'd like me to consider before sentencing?
No, sir.
All right. So, Mr. Wing, first of all, I'm gonna grant the city's motion to dismiss 580864579. And I'll grant the motion to amend 580657416. I think that covers that. So, Mr. Wing's been in since when?
12.
All right. So, Mr. Wing, I mean, you were here in court last time and you're always very good about showing up at court. And I appreciate that. But the problem is when we let you out, you violate the conditions, you commit new crimes, you go to places you're not supposed to go. Your mom's here again. Your mom comes with you after most of these hearings. How do we correct this behavior? Do you know?
I just gotta not go to those places. It's difficult for me when I have to wash my bedding.
Yeah.
All this other stuff that's going on with other people, and I have to go all the way to like Aberdeen to do my lawn. That's ridiculous to have to go that far to do my grocery shopping. I have to go all the way to West Side Olympia to do my grocery shopping. That's ridiculous. That's
Well, the dilemma is this. You've been trespassed from those are private entities, right?
Yeah.
Trespass from those entities. So, you're going to have to come up with a different plan because if you keep doing it, you're going to be back again and it's going to be again and again. I mean, the cycle is just going to continue. I mean, your mom obviously gives a, what about this because she's here. I think she cares until she doesn't care because you don't seem to care. So I think if you seem to have the ability to exercise some support, but I think you need to earn that support. You understand that?
Yeah.
All right. So I'm going to follow the recommendation. I'm going to impose 90 days in jail under the 650 cause number. I'm going to suspend 18 days, which will make, what is that? That's going to be 72 days suspended. $1,000 fine. I'll suspend all $1,000. Jurisdiction will be held for 12 months. Under 416, I'm going to impose 90 days in jail, suspend all $90,000 fine, suspend all $1,000 for a period of 12 months. And then cause number ending 939, going to impose 90 days, going to suspend all 90 days, impose $1,000, suspend all $1,000. Conditions are going to be appear timely at all court hearings, no criminal law violations. You're not to go on the property of the Tractor Supply. You're not to go on the property of the AMPM Mini Mart that's located in Yelm, and you're not to go on the property of the Nisqually Plaza. Do you understand that?
Yes, sir.
Okay, Mr. Wing, I really do wish you good luck. I hope we don't have to have what happened on the 12th happen again. All right?
Yes, sir.
All right, good luck to you. Thank you. Good luck. Thank you. I've signed the wing order. I have one more in custody. Did they bail? Okay. All right, great. All right. Okay, all right, let's go to the 9 o'clock. Here's that one for the, you said this won't be. Okay. All right, who do we have how do we have online? Sorry. All right, with Tyrone Edwards. Go ahead and have a seat. Good morning, Mr. Edwards. This is call number 580-312-315. Mr. Edwards is present. We have counsel, Mr. Harbison, present via Zoom. Charge is reckless driving. Good morning, Mr. Harbison.
Good morning, Your Honor.
What are we doing with Mr. Edwards' case today?
Your Honor, we're asking the court to accept a change of plea in this matter. I believe the city is going to be making a motion to amend the reckless driving charge to that of reckless endangerment.
All right, is that
That's correct, Your Honor.
okay? All right. All right, Mr. Edwards, I've been handed forward a statement of defendant on plea of guilty to an amended charge of reckless endangerment. Have you had enough time to go over this document with your counsel?
Yes, Your Honor.
And did they read it, or did you read it, or a little bit of both?
Both.
Okay. And I'm going to go over some points on it. Paragraph 5 contains a number of constitutional rights that you understand you're giving up by pleading guilty.
Yes, Your Honor.
And Mr. Harbison, do you have a chance to go over any potential immigration issues with Mr. Edwards?
I did, Your Honor.
Thank you. All right, and this is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand that there's a recommendation, I'm assuming, between the parties, which I see, but I don't necessarily have to follow it. I could sentence you up to the maximum.
Yes, sir.
All right. All right, so as paragraph 11 has a statement, and it states, on or about May 25th, 2025, in the city of Yelm, I was doing donuts in a neighborhood in willful and wanton disregard for the safety of other persons and property. Is that your statement?
Yes, Your Honor.
Okay, so as to the charge of, the amended charge of reckless endangerment, how do you plead, guilty or not guilty?
Guilty.
Okay, find your plea is made knowingly and voluntarily, and no one's made any threats or promises of any kind to cause you to enter the plea. And I'll sign this judgment, or sign this plea of guilty, and I'll hear from the city first as terms of sentencing.
Your Honor, it's an agreed recommendation.
Okay. Mr. Harbison, anything additional?
This is an agreed recommendation. He's a young man that just got in a lot of trouble in a hurry. I know he has pending cases in other courts, Your Honor. We've talked about his driving record and what he needs to do, and we're hopeful he resolves those cases that are pending in his favor. I know he's just resolved this case and his Lakewood case.
Okay. And Mr. Edwards, anything you'd like me to consider before sentencing?
No, Your Honor.
All right. So I remember this case, and for reasons that remain unknown, between July of 2025, and this case was in May of 2025, but from July 2025 to September of 2025, you have a racing charge, you have neg driving second, you have a reckless driving, you have a reckless endangerment, you have another reckless driving that we found guilty to in Lakewood. But there's been nothing since September, which is great. What changed?
I don't know. I made a lot of mistakes, and I realized, and I'm at the age now where I'm trying to get a job in a house.
Yeah.
So I just got a great job, so I'm focusing on just
Okay.
being a better person.
And how old are you?
I'm 20, about to be 21 in May.
Okay. So, I mean, yeah, I can tell you and I'm sure Mr. Harbison's probably told you, you're a young man. And if somebody looks at this, they're not even gonna give you the time of day.
Yeah, no.
And until you earn the ability to get the time of day. So what I'm gonna do is this, I'm gonna follow the recommendation. I'm gonna impose 364 days in jail. I'm gonna suspend all 364, and I'm, okay, I didn't know, I was gonna make it 24 months. Probation monitoring fee of $350. There was also a driving class, I thought was part of this as well. Is that correct?
Yes, Your Honor.
What was the driving class? Was it level 2?
Level 2,
Traffic
yes,
safety
Your Honor.
course, okay. I think that's level 2 driving course. I want you to complete that within, have you done it yet?
Yeah, I did it for Lakewood.
Okay, you're gonna have to do it again.
That's okay.
Okay. Have you do it within 30 days?
Okay.
And get proof to the court. Suspended jail time is gonna hang over your head for 2 years, okay? If you get another reckless driving, you're gonna be brought back in here and I will unsuspend some time. So it sounds like hopefully you've got it figured out. You've gone 3-4 months now without an issue. So I don't need to discuss the risk you're putting everybody else at by doing that.
Yeah,
All
I
right?
understand.
Okay. All right. Anything else on this matter?
Anything from defense?
All right, Mr. Edwards, I wish you good luck and I hope I don't see you again in here.
Thank you,
All right.
Your Honor.
Yeah, good luck. Oh, hold on, Mr. Harbison or Mr. Edwards, you're gonna be able to get a copy of this at the window. Okay.
And Your Honor, I had one more matter. William Gardner, is he present?
Yep, I got a yes. William Gardner, is it Gardner? Yeah, please. Is it pronounced Gardner? Okay. All right, this is City of Yelm versus William Gardner, 5803-12288. Mr. Gardner is present. Mr. Harbison's present via Zoom. What are we doing with Mr. Gardner's case today?
Yeah, we're looking to resolve his case today. I believe the city's going to be making a motion to amend the driving license suspended third charge to that of the infraction, no valid operator's license. And in exchange, we're going to enter a plea to the ignition interlock violation with an agreed recommendation of no jail time, $150 fine plus court costs. Mr. Gardner recently entered a similar resolution with the city of Enumclaw. I do believe he understands he's given up his constitutional rights today.
All right, and you are William Gardner?
Yes.
All right, Mr. Gardner. I have before me a statement of defendant on plea of guilty to one count of operating a motor vehicle without ignition interlock, and then there's an amendment from a DWS third degree to a infraction. Did you have enough time to read over this with your counsel, or did they read it to you, or a little bit of both?
Both.
Okay,
Yes, Your
and
Honor.
feel like you've had enough time for them to answer all your questions?
Yes, Your Honor.
Okay. Paragraph 5 of this document contains a number of constitutional rights. You understand that by pleading guilty, you're giving up those rights?
Yes.
And you understand that the maximum penalty for operating a motor vehicle without ignition interlock is 364 days in jail with a $5,000 fine. You understand there's recommendation. I don't have to follow that recommendation. I can sentence you to the maximum.
Yes.
All right. Paragraph 11 states, and Mr. Harbison, do you have a chance to discuss any potential immigration issues with Mr. Gardner?
Sure.
Thank you. All right, Mr. Gardner, paragraph 11 states on March 9th, 2025 in Yelm, Washington, I drove a vehicle without ignition interlock device and as was required by the Department of Licensing. Is that your statement?
That's correct.
So as to the charge of operating a motor vehicle without ignition interlock on March 9th, how do you plead, guilty or not guilty?
Guilty.
Okay, I'll find your pleas made knowingly and voluntarily. No one's made any threats or promises of any kind to cause you to enter the plea. And I'll hear from the city as to sentencing.
Your Honor, it's an agreed recommendation.
Okay, Mr. Harbison, hear from you.
It's an agreed recommendation. He's working on getting his driver's license reinstated. He's having some problems with the ignition lock company doing that. But hopefully he'll be relicensed soon.
Okay. All right, and Mr. Gardner, you don't have to say anything, but this is your opportunity to say anything before sentencing if you so choose.
Have nothing to say, sir.
Okay, so yeah, you're currently still revoked third degree. Oh, sorry, that's hold on, I want to just pull up your history really quickly. Um, Oh, you're suspended third. Okay. All right. Well, Mr. Garnier, I mean, I'm sure Mr. Harbison's talked to you about this. You get these ignition interlock violations and they just make more licensing issues. So I'll follow the recommendation. Going to allow the amendment of the DWS third to no ball with ID. Find it committed, impose a penalty of $150 on that. On the operating motor vehicle without ignition interlock, and impose 364 days in jail. Going to suspend 364 days for 24 months, and impose $5,000 fine. I'm going to still suspend $4,700, so $300 fine on the no ignition interlock. Total of $450. You'll be able to make payments on that. The conditions are going to be as follows. You appear timely at all scheduled court hearings. You're going to have no criminal law violations. You're not to drive without a valid license or proof of liability insurance. And you're to comply with any ignition interlock requirements from the Department of Licensing. You understand that?
Yes, Your Honor.
Okay. We'll get this order up to speed, and I'll have you sign. I'll sign it. I'll have it at the window. Okay, good luck to you, Mr. Gardner. All right, Mr. Harbison, any other matters for you today?
That's all, Your Honor. Thank you. Have a great day.
Thank you. You as well. Okay. Any other matters on the 9 o'clock? All right, do we have a Danielle Schaus? No, all right, why don't you pull up Mr. Crone?
I have one ready, Your Honor. Sorry, the Zoom was loading for a minute there.
Okay. Good morning, Mr. Crone. This is cause number 5A0864572, City of Yelm versus Daniel Schaus. Are you appearing for Ms. Schaus this morning?
That is correct, Your Honor. And for the record, Attorney Jay Crone on behalf of Ms. Schaus via Rule 3.4, we are in great communication. She did authorize me to appear on her behalf today and request what I believe will be a final continuance. She just got her evaluation a couple of days ago. We are waiting for that report. And based on that report, I anticipate us being able to resolve this case at the next court date.
Sounds good. Okay. Any objection from the city?
No, Your Honor. I'm in communication with Mr.
Okay, good. We're going to continue this matter to March 12th, 9 a.m. Execute a waiver, commencement date of March 12th, 2026, expiration date of June 10th. And we will see, hopefully this case will be resolved at that court hearing.
All right. Thank you so much. Have a great rest of your day, everybody.
Thank you. There's Sean Jordan present. All right, I'll pull up Mr. Rob. Oh,
sorry about that. And Zachary Robbins appearing for attorney of record, Anthony Gargill representing Mr. Jordan. We're waiving his presence or requesting to raise his presence today under 3.4. Today, we're just asking to continue to the next hearing date. I'm in good contact with the prosecutor. We both anticipate the next hearing being the last one.
Okay. Any objection from the city?
No, Your Honor. It's actually agreed.
Okay, so this is City of Yelm versus Sean Jordan, 5A0760233. 9 o'clock calendar. Do I need an order? Do we need anything? I don't see anything in O courts.
Your Honor, I think we're setting within speedy. If we're not, though, I'm happy to put in a waiver.
So they just want to keep.
Well, I apologize.
We have speedy until April, so can we just give them a, okay, we're just going to give you a hearing notice. Okay, that'll work. Okay.
Appreciate it, Your Honor.
What day, what's our date going to be? March 12th or March 26th, Mr. Robbins?
We have the March 12th, Your Honor. Thank you.
Do you think we'll get it resolved that day?
I really, really anticipate that, Your Honor.
Okay, good. March 12th at 9 a.m. All right, see you March 12th, 9 a.m.
Thank you, Your Honor. Have a good morning.
Thank you. You too. Anybody else online? Which case? Okay. Good morning, Mr. Holcomb. How are you?
Good morning, Your Honor. I'm doing well. How are you doing
Good.
this morning?
I'm well. What case are you here for today?
So I am here for two cases today. The first one I have is a pretrial for Xavier Lindy.
All right. And do we, Mr. Lindy? Mr. Lindy is present in the courtroom. This is cause number 5A07000137 and 5A07544693, both on for pretrial. What are we doing today?
This will be a defense motion to continue.
Okay. Cities, any objection from the city? No. Okay. So it looks like, Mr. Holcomb, so both of these cases are from July of 2025. Are we, or one's July, the other's August. Are we of the, I mean, are we, I don't need the parties to tell me exactly what's going on, but are we moving towards some sort of settlement, waiting for something, or where are we at with this case?
I can give the court a bit of background on this case. So this case previously, I believe, was assigned to Mr. Timothy Oakley, who is no longer with Next Law. So I inherited his cases as well as other caseloads from the firm. I'm not positive as to when Mr. Oakley was formally off the case, but part of the reason for the delay here it's in no way attributed to my client. It's entirely due to him having some turnover when it comes to attorneys.
Okay. So what I guess what I want to do is I'm okay setting this to March 12th. But I'm not going to, I don't want to do any more continuations after that. Just because these cases are getting kind of stale. So I understand the issue. Your attorney is absolutely correct. I mean, sometimes things get delayed, but when we start getting out into the 8 to 10 month region, it gets a little bit tougher. So, okay. So is March 12th going to give the parties enough time, or should we move it later than that?
I think that March 12th is a good point. I think it's a good target for us to shoot for.
Okay. All right, we're going to reset both matters, Mr. Lindy, to March 12th, 2026 at 9 a.m. Stay in touch with your attorney. If you haven't heard from them in a couple of days, check in with them, and let's keep this moving forward, okay? And again, I've the waiver here, commencement date of March 12th, expiration date of June 10th. I will go ahead and sign this order and send you on your way.
And Mr. Lindy, whenever you have time, if you could just reach out to Next Law anytime during business hours between 8:30 and 4:30 and set up an appointment. I think that's a good way for us to get more traction on this case, is for you to sit down and meet with the attorney, okay?
All right. Thank you, Mr. Lindy. You may go. Mr. Holcomb, other matters?
Yes, Your Honor. I do have one other matter. That matter is Michael Wilson.
All right. Good morning, Mr. Wilson. Mr. Wilson's present in court. Cause number 5A03-12298. Charges DUI. Mr. Holcomb is present via Zoom. What are we doing with Mr. Wilson's case?
It's a similar situation here, Your Honor. This is a defense request for a continuance. This is another case that used to belong to Mr. Oakley.
Okay. Okay. Any objection from the city? Okay. And so again, same thing, Mr. Holcomb, not going to be a broke record. This case is from April of 2025. So looks like the proposal is to reset this matter to March 12th. This will be the last formal continuance. Is March 12th going to give everybody enough time to get this case resolved? Potentially.
I believe it's a good target date for us, Your Honor.
Okay, let me just look at one thing here. Okay. All right, Mr. Wilson, I'm going to sign this order. Next court date's March 12th, 2026 at 9 a.m. Commencement date on this is going to be February 26th of 2026 with an expiration date of May 27th, 2026. Hearing no objection from the city, I'll go ahead and grant the continuance, and just noting for the record, it's the last, this will be the last one. Otherwise, we'll just start setting for confirmation and trial so we can keep this moving forward. Okay, be in touch with your counsel and we'll go from there. Okay, get a copy of the order at the window. All right, Mr. Holcomb, I've signed that order. Anything else for you today?
Nothing further this morning, Your Honor. Thank
Okay.
you.
Have a good rest of your day. All right, any other matters that are ready? Ms. Bowden? Okay. Okay. Morning, Mr. Farrell. Good morning. Appreciate you being here early. This is cause number 580-859892 and 580-859893. There's a tracking mitigation hearing. Ms. Bowden, good morning. What are we doing with Mr. Farrell's case today?
City's going to amend the breakfast driving, and we do have an agreed recommendation for sentencing. I think the infraction's getting dismissed. We're prepared to go forward. I did print out the guilty finding. I could go over it with my client. He understands.
Okay. Is there a motion from the city?
Yes, Your Honor.
Oh. All right. And you are Grant, and I'll grant that motion. You are Grant Eugene Farrell?
That's correct.
Mr. Farrell, what's your highest level of education completed?
High school, 12th grade.
All right. I had before me a statement of defendant on plea of guilty. Did you have a chance to read through this with Ms. Bowden, or did she read it to you, or both?
We did both.
Okay. And you feel like you've had enough time with Ms. Bowden to answer, for her to answer any questions that you may have?
Absolutely.
Okay. So I'm going to go over some highlights of it. Paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand that you're giving up those rights by pleading guilty?
Yes, I did.
And Ms. Bowden, have you had a chance to discuss any potential immigration issues with Mr. Farrell?
I have.
Thank you. And Mr. Farrell, this is the amended charge is a gross misdemeanor, means the maximum penalty is 364 days in jail with a $5,000 fine. There's a recommendation contained within this agreement. You understand I don't necessarily have to follow that recommendation. I can sentence you up to the maximum.
Yes, I did.
Okay. And paragraph 11 states, in the city of Yelm, on November 4th, 2025, I drove a motor vehicle with willful wanton disregard for safety of persons or property by getting in an accident after I consumed alcohol. Is that your statement? So as to the charge of reckless driving alleged to have occurred on November 4th, 2025, how do you plead guilty or not guilty?
Guilty.
Okay. Find your plea is made knowingly and voluntarily, and no one's made any threats or promises that cause you to enter the plea. Hear from the city as it relates to sentencing.
Your Honor, it's an agreed recommendation. Just ask that you follow as laid out in the plea.
Thank you. Ms. Bowden.
Your Honor, I do have an evaluation for the court. My client is engaged in treatment. He's doing IOP. He's doing well. It's private pay, so I was shocked at what they charged him, but he's been going and he's doing well, and he knows the benefit of what he's getting today. And I see him back again. I'll hand forward the assessment. Also.
Thank you very much. All right, Mr. Farrell, anything you'd like me to consider before sentencing?
I understand the consequences of my actions and I'm moving forward to do the right thing.
Okay. All right. All right. I will go ahead and follow the recommendation. Going to impose 364 days in jail, going to suspend 364 for a period of 24 months. I'm going to impose $5,000 fine and suspend $3,500 of that. going to impose a $250 monitoring fee. $43 conviction fee. Fine amount would be 12. So it looks, I see what you did. You made it 1,500 total. Okay, all right, I'm fine with that. You'll be able to make payments on that. All the conditions are gonna be no criminal law violations. You're to appear timely at all scheduled court hearings. You're not to drive without valid license or proof of liability insurance. You're not to drive or be in physical control of a motor vehicle with alcohol concentration of 0.08 or THC level of 5 nanograms per milliliter of whole blood or higher within 2 hours. No, this says no moving traffic violations. Is that agreed?
Yes.
Okay. No moving traffic violations. That's for 24 months. Okay. Do not refuse to submit to a breath test or blood test upon request of law enforcement. Don't refuse an alcohol drug test upon request of court, probation, or treatment provider. You're to obtain an alcohol drug evaluation, do whatever treatment's required, which looks like you've started. That's great. Also going to just add to this that you're not to operate a motor vehicle or you're to follow all rules as it relates to the Department of Licensing, Ignition, and Interlock requirements. Okay. Have you filed proof of the and complete a victims impact panel? Has that been done yet? Victims impact panel?
You get that done.
Okay. Give you 90 days to get all those things done and provide proof to the court. Anything I missed?
Got it all. And I'm well aware of what these obligations are.
Okay. All right, Mr. Farrell. I did. There you go. You're welcome. And the infraction will be dismissed. Mr. Farrell, good luck to you. All right.
Thank you.
Okay. We'll sign this order. There'll be a copy at the window. Okay. Simon Raleigh. Come on forward, Mr. Raleigh. Cause number 3A0271250 and 5A0692752. 250 is on for compliance diversion, and we have a pretrial under the 752 cause number. Mr. Simon Raleigh's present with counsel in person. What are we doing with Mr. Raleigh's case today?
Your Honor, the city's moving to dismiss the two causes under 5A0692752 and taking no action on compliance diversion.
Okay. All right. And Ms. Bowden, I assume no objection? All right. Mr. Raleigh, so the city is going to dismiss what would otherwise have been the violations of a diversion. I just want to remind you that you are on pretty significant conditions, and there's a lot riding on this in terms of the DUI that you're on a diversion for. You understand that?
Yes, sir.
Okay. Let me look at one other thing. And I just give a note, we have no assessment or victims impact panel completed for Mr. Raleigh.
Yeah, I emailed it.
All right.
Yeah.
Yeah, we were actually kind of helping Mr. Raleigh with the other matter. He advises that he emailed an assessment to our office.
Pictures of it, I believe, on my phone.
And we can get that filed. He has to do a victims panel too.
Yes. We need a copy of the assessment and the victims impact panel.
Okay, well, he has it on his phone.
There's ADIS.
And just have him provide it to the court. Just need to make sure you get it to the court, Mr. Raleigh.
Your Honor, I do notice on his phone, he does have the victims panel. He does have the ADIS. So he's got the assessment. I'm going to have him re-forward those to my phone. I will get those filed with the court, and I'll also make sure it doesn't require any further treatment.
Thank you very much. Okay, I will sign this order. Mr. Raleigh, good luck to you. Stay in touch with Ms. Bowden so everything gets filed, okay? All right, good luck to you. And then last on the 9 o'clock is Sean Jordan. Oh, he did. Okay. All right, that concludes the 9 o'clock calendar. I think we're just waiting. Record on the, and if we could maybe address on the 9:45 calendar, item number 3, Jesse Eubanks. Okay. Good morning, Mr. Eubanks. This is cause number 580657417. Mr. Eubanks is present with counsel on for arraignment, malicious mischief. Let me inquire as to his financial status. Yeah. Why is he on the, why is he on the warrant watch? Gotcha. Roughly. $1,500. What kind of wage? Oh, okay. So that's 3,000 a month after taxes. It's full time. It's a full time. When are you going to start the job? Okay, when do you think? Roughly.
Well, longest will be another week.
Well, right now he's not employed at the moment, but he does apparently have, as I understand, sort of a job offer, and there's some paperwork that's got to be completed. He's going to be making $18 an hour, which I think is about 3,000 a month. So after taxes, it's probably a couple $1,000 a month-ish. All right, I'll find him eligible for court-appointed counsel at no expense to him, and I'll turn it over to you. Stipulate to probable cause, ask the court to enter a not guilty plea. All right, Mr. Eubanks, based on statements of your counsel, I'm going to waive further reading of rights, find probable cause purposes hearing only, and enter a plea of not guilty. Hear from the city in terms of conditions of release.
PR, Your Honor.
Okay. Okay. Mr. Eubanks, I'm going to release you on your own recognizance. Under the following conditions. Going to, you're not to commit criminal law or criminal traffic violations, pure timely at all scheduled court hearings. You are not to go onto the property of the grocery outlet in Yelm. Do you understand? You know where that property is? Okay.
Is that just the grocery outlet? Might be able to shop at Goodwill?
I think this just involves the grocery. Well, it's located at the Nisqually Plaza. What's the city's position on that? This happened in front of the business. So it wasn't in the grocery outlet, but it was at the Nisqually Plaza. I think that would include the Nisqually Plaza.
City's gonna ask that he doesn't return to the Municipal Plaza.
I'm gonna have you stay away from the Nisqually Plaza while this is pending, okay? And I'm gonna ask, it looks like there was some damage to some pots allegedly. I'm gonna ask the city, just maybe make a note to contact, find out what we're talking about damage numbers wise, depending on where this case goes. So no contact with Nisqually Plaza while this is pending. We're gonna give you contact information from Mr. Haverco. I want to make sure you stay in touch with him, make sure he has good information for you, all right? And we're gonna give you a new court date of March 26th at 10 a.m. I don't want you calling Mr. Haverco on March 25th. I want you talking to him before then, okay? All right. Okay, anything else on this matter?
Nothing else, Your Honor.
Okay, I'll sign this order and we'll see you back here on the 26th.
I'll be calling you about a week prior to court.
And you'll get a copy of the order at the window. All right, thank you. Good luck to you.
And I believe the other 945 matter that's here, Your Honor, is item number 7, which is Lehman Dale Thomas.
Lehman Dale Thomas. Good morning, Mr. Thomas. Let's see. Cause number 6A00896667. Mr. Thomas is here on a warrant quash or as a result of a warrant quash. Mr. Raymond back on January 12th. But he's here today and he's with counsel.
And I don't believe I've been appointed, so I'll talk to him for a moment.
Okay.
He's just kind of cutting firewood, doesn't have a regular source of employment, so just has a little bit of from time to time income. It's not much.
Okay, I'll find him eligible for court appointed counsel and appoint Mr. Haverco.
And pursuant to that, stipulate to probable cause, ask the court to enter not guilty plea.
All right. All right, I'm gonna we're way further reading, further advisement, find probable cause purposes hearing only and enter plea of not guilty on your behalf, Mr. Thomas. Conditions of release from the city?
Your Honor, PR.
Okay. We'll quash and obviously we'll quash the warrant as well. All right, Mr. Thomas, we're going to reset this matter for March 26th at 11 a.m. Just like I said before, you're going to be given information on how to get a hold of Mr. Haverco. Get a hold of him if you haven't heard from him. Don't do it don't wait till the day before the next hearing. Conditions are standard conditions, no criminal law violations, appear timely at all court hearings. Keep everybody up to date with your legal name and date of birth and contact information. Okay? Give you a copy at the window. Good luck to you.
Before you go, sign here. Okay, free to go.
All right, I'll sign this order. And then, so on the 945, just gonna whip through these really quickly. Is there a Killian Barrett present? Anybody on Zoom? Oh, okay, is there a Ariel Anderson present? Anybody on Zoom? Okay, based on no appearance, and on these things, I would normally require, I imagine I would normally require the defendant to be here too, so either way, we're gonna strike it, okay? Next matter, Aaliyah Danielle Clark, cause number 5A09-18089 on for arraignment, resulting from, we're here today on an FTA from December 4th of 2025. And my understanding procedurally is Ms. Clark would have contacted and got put on this docket. All right, and they pay something for doing that? Okay, we will reissue the warrant. City versus Adam Hash. Cause number 4A0745-406 and 4A0745-407, DWS second and theft third. So how did they get on the calendar? Okay, we'll make it so. Thank you. And then Isla Scheidek. Isla Scheidek, cause number 2A09 3977 FTA from November. Any word from Ms. Scheidek? Okay, reissue the warrant or leave it intact, whichever one. All right, 10 o'clock.
See who's here. So is Nicholas Armstrong here? Come on up. Let me see. And let me get to that spot.
Good afternoon, good morning, Mr. Armstrong. Call your case, City of Yelm versus Nicholas Armstrong, 580-915-7778. Mr. Armstrong is present with counsel, out of custody.
So matter comes on for a pretrial hearing and we have placed, I've had an opportunity to discuss the matter with him. And we placed a stipulated order of continuance into O courts, matter to be continued for 12 months, no new criminal law violations. City's not asking for financial obligations on this case. After which time, if he completes the agreement, the matter to be dismissed.
All right, Mr. Armstrong, have you had enough time to go over this agreement with Mr. Haverko? And so in a nutshell, this is a contract in exchange for you to doing certain things or you not doing certain things. The city's agreeing to not do certain things and to do certain things at the end of this. So this matter is going to be continued for a period of 12 months with no findings. And basically during that period of time, you are to maintain law-abiding behavior, make all court hearings, and stay out of trouble. If you do that at the end of 12 months, this matter will come up for review. And if you're clear, everything's good, the matter will be dismissed, nothing else for you to do. If you show up or if we pull the file in a year and it looks like there's new law violations or some other nonsense, you'll be brought back in and then we'll deal with the case and you'll likely be convicted. Do you understand that? Yes, okay, you want me to sign the order? Yes, I will sign the order. All right, Mr. Armstrong, you'll get a copy of this at the window. If you have any questions, you get a hold of Mr. Haverko and we'll go from there. Good luck to you.
Thank you, Your Honor. And then we're going to jump to the end of the calendar for Mr. Armstrong's co-defendant. That would be Ms. Weston Haver. It's items number 14 and 15. It's the same case and same agreement. I'm going to have her sign the proposed stipulated order of continuance now.
Okay, all right. Ms. Weston, oh, go ahead.
I'm sorry. And as part of the agreement, the city would not be moving for any compliance action on the compliance matter. So the city's not going to be making a motion on that for any further action.
All right. All right, Ms. Weston Haver, you heard what I went over with Mr. Armstrong. Do you understand the nature of what you're entering into? And I don't know the circumstances here, but you know, the violation of a no contact order in this situation is, and again, I don't know if it's a situation where there's people want to have contact or whatever, but there's a court order that's in place. So it's really not what the parties want. It's the fact that a court, whether it's me or somebody else, directed you not to do something. So it's sort of a governmental control thing, which is what it is. So I'm going to follow this recommendation. You're going to agree to stay out of trouble for 12 months. Maintain law-abiding behavior and appear at all court hearings. If you do those things at the end of 12 months, this matter in particular, the new matter, the 5A09157779 would be dismissed. But most importantly, you have the other matter that will remain intact and not be revoked. Understand that? You're on a compliance for another diversion agreement.
The city's not moving for revocation on your other matter.
Yeah, make sense? Okay, all right. I think we're on the same page. I just want to make sure you understand it. So, all right, I'll go ahead and sign this order. Be a copy at the window. If you have any questions, you contact Mr. Haverko before things go sideways, and good luck to you. All right.
Hey, Freddie. And I don't know if he's here or not. I'm just going to call his name. Is there a Zachary Boatwright here? Okay, just remain seated. I haven't spoken with you, so just remain seated. And is there a Deanna Brass here? Then just remain seated. We haven't We haven't, well, actually, let's have Deanna Brass come up. Yeah, Deanna, come on up. This comes on matter for a pretrial. Per the docket, she had last failed to appear, so I believe this is her first appearance. And have not had a chance to talk to her because I don't have a valid number. Do you have a current number down? Okay. 7314. So would like to just set a new pretrial, and she's just now provided me an updated number. So hopefully I'll be able to talk to her ahead of time prior to our next court date. Okay. Any objection from the city?
No objection.
All right. All right, Ms. Brass. So you're going to be we're going to reset this matter. The pretrial to March 26th at 10 a.m. You're going to be given contact information from Mr. Haverco. He should make sure make sure you give him your good contact information. And see you back here on the 26th of March, okay? Okay, thank you. Talk later. And next matter would be Megan Brown. Is she here? Megan Brown? I had a plea form prepared, so I thought she'd be here. We'll address that later. Okay. Let's see. Let's see here. Chavez? Carlos Chavez? Well, he's present. Hold on one second. Are we ready for Mr. Chavez? Yeah, we are. Okay. All right. Good morning, Mr. Chavez. I'm just gonna have you take your stocking cap off when you're at the table. Thank you very much. All right, what are we doing with Mr. This is cause number 580-886-384, City of Yelm versus Carlos Manuel Chavez. Mr. Chavez is present with counsel. Yeah, matter comes before the court for pretrial hearing on a theft charge. Parties have reached an agreement. I'm now going to have him sign a proposed stipulated order of continuance. Sign. And there we go. You sign the form and let's see. Yeah, and this is the matter to be continued for 12 months on the condition of no new criminal law violations, payment of a $250 court fee, at the end of which time the city would move to dismiss. Okay. All right, Mr. Chavez, do you have enough time to go over this with Mr. Haverco? Okay, so this is an agreement. You're going to not have any criminal law violations. I'm also I'm going to order you not to go to the Walmart for the period of time on this. You're probably already trespassed from there anyways. Appear at all timely court hearings, pay $250 over the next 1 year. And if you do those things at the end of this 12-month period, the matter is dismissed. If you violate any of those conditions, you're brought back in and your guilt or innocence would be determined based on a reading of the police reports, which would likely result in your conviction on this. So this is an opportunity for you to get this off your record and not carry it with you. And I hope you take advantage of that. Okay? Is that yes? Yes. Okay. All right. Okay. I'll go ahead and sign the order. You'll get a copy at the window. They'll show you how to make the payments. Okay? All right. Good luck to you. Okay. Next matter would be if she's here, Leah Cox. Come on up, Leah. Good morning, Ms. Cox. This is cause number 580700159. Ms. Cox is present with counsel. Mr. Haverco, Your Honor. And then we also, looks like we might need an update address on Ms. Cox if we haven't gotten it yet. I'll let you do it at the clerk's, do it at the window, but just make sure at least if it's your parents, if that's where you get mail, if we can get that updated. Okay. It's working. Yeah. Oh, it is. It is. Yeah. Yeah. There you go. So matter comes before the court for a pretrial hearing on theft. Parties have reached an agreement. She's going to enter a plea. However, it is an Alford plea, and she and I discussed this matter, and while she doesn't feel or agree that she's guilty, we reviewed the evidence that's available to the city, and agree that if the evidence available to the city were presented to a finder of fact, along with whatever evidence the defendant has, we agree that it's highly likely that a finding of guilt would be entered. And so based on that, she's entering a plea, and also for the additional reason she wants to take advantage of the city's plea offer.
Okay. Yeah. All right, Ms. Cox, is that correct, what Mr. Haverco just said? All right, so Ms. Cox, I'm going to go over this. I have before me a statement of defendant on plea of guilty to a charge of theft third degree. What's your highest level of education, Ms. Cox? Okay. All right, and the charge before me is cause number 5807-00159, theft third degree. You have enough time to read through this document with Mr. Haverco? Did he read it to you? Do you read it to yourself or both? Okay. And I'm going to go over some highlights. Paragraph 5 contains a number of constitutional rights. You understand that you're giving up those rights by pleading guilty? And did you have a chance to discuss any potential immigration issues, Mr. Haverco? We did discuss those, Your Honor. Okay. All right. And Ms. Cox, the maximum penalty for a charge of theft third degree is 364 days in jail with a $5,000 fine. You understand there's a recommendation here that I don't have to follow. I could sentence you up to the maximum. Okay. And this is the form of an Alford plea. So I'm going to review the police reports, and events allegedly occurred on September 29th, 2025 in the city of Yelm. All right. So I'm reviewing the police reports here, Ms. Cox, and it says that you were contacted outside the point of sale, or for the Walmart in Yelm. At that time, you were contacted with some items. You were detained, and a statement was allegedly made by you. And I understand this is an Alfred plea. I was going to let you know what that statement in the policeman was. It stated that you stated at that time that you were not trying to take the items, but you did not have the money to pay for the items. Based on the evidence contained in the police reports, I will find there's sufficient evidence to support an Alfred Newton plea in this case, and will make a finding of guilty and accept your plea at this time as knowingly and voluntarily, and no one's made any threats of promises of any kind to cause you to enter the plea. Are we moving to sentencing today? We are, Judge. 1 second. All right, I'll hear from the city.
Your Honor, it's an agreed recommendation.
Mr. Haverco, it's agreed, Your Honor. All right, Ms. Cox, you don't have to say anything before sentencing, but it's your option if you'd like to say anything. Is there anything you'd like to say? Okay. All right, let me look at a couple things here. All right, so Ms. Cox, I mean, you don't have a significant history of these kind of charges, so I'm hoping whatever was going on, hopefully is maybe resolved or fixed or squared away. Okay. While I'm not particularly excited about Alfred pleas, I will follow the recommendation in this case. I'll tell you the reason I'm not particularly excited about Alfred pleas, and I do think it puts defendants at a little more risk, and Mr. Haverco knows this, is there's a certain amount of grace given for people to take responsibility. And when I have somebody say, well, you know, I don't think I did it, but, you know, I'm going to plead guilty. And then that forces me to read the police reports, which sometimes are worse than somebody just saying, hey, I screwed up and did it. Okay. I just want you to, just of note. So hopefully we don't see again on these kinds of things. I'm going to impose 364 days in jail. I'm going to suspend 364. Impose $5,000 fine, suspend $5,000 for a period of 12 months. Going to impose a $250 probation monitoring fee. You're not to go back to Walmart, which you're already prohibited from doing that, but you'll be prohibited from here as well. You appear timely at all court hearings. You have no criminal law violations. Understand those conditions? All right. I'll go ahead and sign the order. And Ms. Cox, I wish you the best of luck, okay? And you'll get a copy at the window. Take care.
Joshua Novello?
Sorry, what was the last name?
Oh, Novello.
Novello, Joshua Novello?
Right.
All right, good morning. This is cause number 5A0150684, compliance diversion, and a 5A0150685, compliance diversion, and a 5A0312314, pretrial. Mr. Novello is present with counsel. Mr. Haverco, what do we got going with Mr. Novello today?
Thank you, Your Honor. The court would just indulge me just a moment. So he's now signing a stipulated order of continuance. Matter to be continued for 12 months on the condition that he have no new criminal law violations, pay a $250 court fee that can be paid, on a time payment basis, at the end of which time the city would move to dismiss, and then the city wouldn't be moving for any other motions on his compliance matters.
Okay. All right. You are Joshua Novello? All right, Mr. Novello, I've got before me a statement, a stipulated order of continuance. You have a chance to go over this with Mr. Haverco? So I'm going to be honest with you, I got a number of issues with this. You're on two other stipulated order of continuances that we now have an accusation of a new law violations. You also haven't made any payments on the other two SOCs. You understand that? Well, you owe 125 on cause number ending in 684 and $125 on cause number ending in 685. And
in Your Honor, if I could just interject, and I appreciate the court's raised eyebrows at this. And just for the court's information, I've known him for a while, so I've had kind of some history with him, and he wound up being charged in Superior Court and went through he's a veteran, and he went through some significant kind of mental health issue, probably PTSD related, went through an entire evaluation process. And so he seems to be, to me, to be in a much better position than he was. And so he's doing much better. He's currently, he had forwarded to me some evidence that he's doing some chemical dependency treatment with the VA. He's also going to be pursuing a course of mental health treatment with the VA. So this was kind of we discussed all this with the city, and so it is unusual, but this is kind of I guess, an acknowledgement, a recognition that he's in a much better place. And so the expectation is that he's going to get things straightened out.
okay. All right, Mr. Novello, again, I just want you to get the help you need, because these kind of things are just, they're burying you a little bit, because you're just getting stuff stacked up. And if hopefully you're going to get taken care of whatever the root issue is here, so that we can stop having these kind of meetings, does that make sense? Okay. So I'll go ahead and sign the stipulated order of continuance. You know the terms, you know what you're supposed to do. You're stay out of trouble, don't get arrested, pay the fines. So there's $250 owed on this one. You owe a 125 and another 125 on the two previous are pending. I'd like those paid. And then you have to maintain law-abiding behavior. Okay? If you do that, at the end of 12 months, these matters will be dismissed. And abide by all existing no contact orders. That's a condition of this as well. Did I miss anything from the city?
No, Your Honor.
And Mr. Haverco? No, you're right. All right, Mr. Novell, I'm going to sign this. I wish you best of luck. And I really hope that you can get these things taken care of. And I wish you good luck with your mental health stuff too. Okay? Let you get squared away at the window. Thank you, Your Honor.
Your Honor, if you could take it.
Yeah, the court will be in recess for a few minutes. Okay. This is Tracy Logan?
Yep, yep.
Did we stay on?
Yeah. Okay. Yeah, he's ready. He's ready to go. I just need to get to the right spot.
All right. Good morning, Mr. Logan. You are here on cause number 5A09157775. Mr. Logan is present with counsel. Mr. Haverco says we are ready to go.
It's going to be, so matter comes on before the court. Let me get to the right page here. For DUI, he's going to be entering a plea to that. The parties will stipulate that it's to be transmitted to DOL as a no test case.
Okay.
And so ready to, so just the usual DUI related conditions and ask the court to inquire.
Okay. All right. You are Tracy Logan. All right, Mr. Logan, I'm gonna get to this in just a second. Have before me a statement of intent on plea of guilty. What was your last level of education completed, Mr. Logan? 12? Okay. All right, and you're charged with driving under the influence. Just so the clerk's aware, do you hear that's gonna be, it'll be referred as a no test? Okay. And the elements are set out in the charging document. Do you have a chance to read through this with Mr. Haverco, or did he read it to you, or both?
I read it.
Okay. Feel like you've had enough time for him to answer all your questions? Okay. And, oops. And I'm going to go over some highlights of this document. Paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. You understand that?
Yes.
And any, discuss any potential immigration issues, Mr. Haverco?
We did, Your Honor.
Okay. And this is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand? There's a recommendation here. I don't have to follow that recommendation. Okay. And then there are also in this sentence of a DUI, there are some certain conditions that I can't go below either. There's requirements of a day in jail. There's certain monetary penalties, things like that. Do you understand that? Okay. All right. So paragraph 11 states on November 15th, 2025 in the city of Yelm, I drove a motor vehicle while under the influence of alcohol. Is that your statement?
Yeah.
So as to the charge of DUI alleged to have occurred on November 15th, how do you plead guilty or not guilty? Okay, I'll find your plea is made knowingly and voluntarily. No one's made any threats or promises of any kind to cause you to enter the plea, and I will sign this order. Sentencing today?
Yes.
All right, I'll hear from Mr. Ratfield.
Your Honor, it's an agreed recommendation.
Okay. Mr. Haverco.
Did you spend it in jail?
Yeah, I did.
1 or 2 or 3? Oh, that's right. He
3 days
thinks he spent 3 days in custody, so just ask for credit for time served, so he wouldn't know any more jail. Ask the court to impose the mandatory minimums and the I would anticipate the court is going to impose the typical DUI related conditions.
Right. Okay. Mr. Logan, anything you'd like me to consider before sentencing? Okay. All right. I'm going to follow the recommendation, going to impose 364 days in jail. I'm going to suspend 361, give you credit for 3 days. You're not going to have to serve anymore. Going to impose $5,000 fine, going to suspend $4,009.50. Jurisdiction will be for a period of 60 months, which means the suspended jail time will hang over your head for a period of 60 months. So long as you stay in compliance comply with the conditions, don't get any new law violations, things of that nature, you won't have to serve any more jail time. If you violate any of those conditions, you'll be brought back in, and I can sentence you to all or a portion of the suspended 361 days. Okay. I'm going to impose a fine of $345, going to impose a TPC, TPD, what is that? That's a traffic safety fee, $102.50. Probation monitoring fee of $250, BAC fee of $250, and basically a justice fee of $43. Total of $990.50. You'll be able to pay $50 a month on that. Following conditions: you're not to operate a motor vehicle, not drive a motor vehicle without valid license and insurance. You're not to drive a motor vehicle without proof of liability insurance. You're not to drive or be in physical control of a vehicle with 0.08 or above, or 5 nanograms of active THC. Comply with all rules and requirements of the Department of Licensing. Don't refuse a breath test if asked to give one by law enforcement or any treatment provider. Have no criminal law violations. Have no alcohol-related offenses. Not to refuse any alcohol or drug tests like we talked about. I'm going to order you not to go to bars or taverns or consume any alcohol, non-prescribed drugs, or marijuana. And going to have you get a alcohol evaluation. Has that been done yet?
Not yet.
Okay, you're gonna have to get an alcohol drug evaluation done within 90 days. You're gonna have to do whatever treatment's required. And you'll have to provide proof of that to the court, and then you'll also have to complete a victim's impact panel within 90 days as well. That cover everything? Yeah. Okay. And I'll just get this finalized, and then we'll get it signed, and you can get a copy at the window. All right, Mr. Logan?
Before you go, I need to have you sign it here, so I'll need to just get the signature page. There you go, sign right here. There you go. Perfect. Okay. You sign the judgment sentence, so you're free to go, and good luck to you. Thank you.
Yeah, good luck, Mr. Logan.
So all these folks here are just for Mr. Boatwright, so I'm gonna go meet with him
Okay.
and, talk
Good.
about his case.
We'll take
I just talked to him. When the court's ready, let's take up the matter of James Bittner. Is that the 11 o'clock? Yeah, I'm gonna fill out a speedy trial waiver. But the party, I think the parties are actually making progress, but it's just been a while because of his FTAs. It's been a
Yeah.
while since I've talked to the guy. So just trying to, all right, this is your James Bittner. All right. Cause number 580-248505, 934-218-406. Mr. Bittner's present for pretrial. These are driving suspended license seconds, as well as some protection order violations. My understanding is Mr. Haverco is gonna do an order to continue. Yes. So, Mr. Bittner, have you been in contact with Mr. Haverco? Okay. You have a good number to call him, because I don't like waiting till the day of court, because then nothing gets done. So make sure you stay in contact with him. And what kind of date we looking at? Let me have some. Proposing a just kind of ordinary course. We're doing a speedy trial waiver that starts the commencement date 3 months, starts it from 3 months from now.
Okay.
So we've got plenty of time, and I anticipate we may wind up doing a bench trial on the protection order violation down the road.
Okay. Yeah. Well, why don't we put it, I just want to put it out long enough so we can at least get it to get some of the cases resolved, and then we could deal with the ones that don't. So, and then end of March? Sure. March 26th?
Yep.
Well, March 26th, 11 a.m.?
Yep.
Okay. All right. We'll fill all this in. Give us just a second. March 26th, 11 a.m. will be the next court date. All prior conditions remain in effect. Let me look at one thing here. Have you been to court on the obstructing law enforcement out of Thurston? Oh, that's us. That's another charge here. Is that right?
Yeah, it's out of the district. It's a district.
Okay. All right. Okay. All right. City aware of that? We have a new charge from January 8th.
Okay. City was not aware.
Okay. All right, Mr. Bittner, the conditions are maintain law-abiding behavior, no law violations. All right. I've just got to reiterate that. So reset it to March 26th, 11 a.m. We'll see you back then. Stay in touch with Mr. Haverco. Okay. Yep. Going back to the 10 o'clock calendar, Zachary Boatwright, item number 2. All right. Good morning, Mr. Boatwright. Thank you for your patience. Righty, let me get to Mr. Boatwright. He is now signing a stipulated order of continuance. Parties will stipulate that the DUI itself should be treated as a no test. And we've placed into courts a stipulated order of continuance, matter to be continued for 24 months, at the end of which time it can be amended to negligent driving in the first degree, the usual DUI related conditions, alcohol evaluation within 90 days, comply with any recommended treatment, victim impact panel. The proposed probation fee is that which would have been the fine for the DUI, $990.50. All right, you are Zachary Boatwright. All right, let me pull this up. I have before me a stipulated order of continuance. You have enough time to read over this with Mr. Haverco? Yes? Okay, and what a stipulated order of continuance is a contract. In this case, it's a 24-month contract. If you maintain law-abiding behavior, pay probation costs of about $990.50 over the course of the 2 years, appear timely at all court hearings, no criminal law violations, don't refuse a test, get an alcohol evaluation, do whatever treatment's required, and complete a victim's impact panel. Do all those things. At the end of 24 months, this case would be amended to a neg driving first degree. You understand that? If you violate the conditions, what happens is you're brought back to the court, and then the court will determine, whether it's me or anyone else, will determine your guilt or innocence based on a reading of the police reports. Okay? You won't be able to call witnesses. You won't be able to challenge the exhibits. So you're not pleading guilty, but you're basically coming up to the brink of it. How old are you, Mr. Boatwright? Okay. Who's Caden? Okay. Do we know the status of Caden's case? He had obstructing on this case. Is Caden here? No? No, it's okay. I don't need to see him. I'm just reading the police reports, Mr. Boatwright, and it sounds like while this wasn't a great night, turned into something it didn't have to be anyways. So I just hope you learn from it, if that makes sense. This is an opportunity for you. This agreement's a good deal. It's an opportunity for you to keep this off your record. I hope you take advantage of it. Get the alcohol drug evaluation done, 90 days, victims impact panel done within 90 days. Pay the fine payments, and hopefully, 24 months comes up, and what I'll do is this: you want to put on the record, and I know this is a contract between the parties. Let me know if the city is completely objecting to this, but looking at Mr. Boatwright's lack of history, he doesn't really have anything. Is the DWS going to track with this too? Okay.
Oh, I think as part of the agreement, city was going to move to dismiss today. Yeah, just as part of the agreement.
Okay, so we'll dismiss the DWS. But what we'll do is this: if Mr. Boatwright has everything done at the 12-month mark, we'll go ahead and, would the city have an objection to moving to dismiss at 12 months as opposed to 24 months if he has everything done?
Yeah.
All right, so Mr. Boatwright, this is a 24-month agreement on its face, but if we review this in 12 months and you've paid all the fines, the costs, you have no law violations, you've completed the alcohol evaluation, done whatever treatment's required, and completed the victims impact panel, this will be dismissed at 12 months. Or not dismissed, it'll be amended to a neg-1 and closed. Do you understand that? All right. Okay, Mr. Haverco, did I miss anything?
I don't think so.
Okay.
Yeah, just as long as the DWLS is officially dismissed today.
Do you want me to add? I can add that. Is it in there? Oh, dismissed. It's dismissed with prejudice.
Yeah.
Got it. Okay. All right, Mr. Boatwright, I will sign this order. Good luck to you. Grab a copy at the window, okay? All right, good luck to you.
On the 11 o'clock, item number 1, Rebel Anderson.
Thank you. Rebel Anderson. Ms. Anderson is present. Give me 1 second to get there. This is cause number 5A08645576. Ms. Anderson is present with Mr. Haverco. What are we doing with Ms. Anderson's case today?
She has just signed a proposed stipulated order of continuance, the matter to be continued for 12 months on the condition of no new criminal law violation, payment of a $250 court fee, overtime payments, at the end of which time the city would move to dismiss.
Okay. Ms. Anderson, you have enough time to go over this with Mr. Haverco? Okay, he answered all your questions? Yes. Okay, so much like the previous situation, this is a opportunity, it's a contract, allows you to have this case dismissed after 12 months. Probation fee, $250, you gotta pay that. No criminal law violations. $10 court hearings. Maintain law-abiding behavior. Think you can do that? Good. Okay. I'll sign the order and we'll get a copy at the window. Good luck to you.
All right, you're free to go. Yep. Next matter is going to be Bridget Bowes. Go ahead and have a seat.
Good morning, Ms. Bowes. So,
It's working. Yeah. Yeah, it just doesn't show, but it's working. Yeah. She has just signed a statement of defendant on plea of guilty. It's going to be to the amended charge of hit and run unattended. And I can mention it now, or we can address it later on the mitigation. The city is proposing to dismiss the no insurance ticket, and then we would make an admission as to the failed to yield $150.
okay. All right, you are Bridget Bose. Ms. Bose, you're here on a couple cause numbers. First one's 5807-00155 with a tracking infraction. I've been handed forward a statement of defendant on plea of guilty to an amended charge of hit and run unattended. Ms. Bose, what's your highest level of education?
I graduated high school.
Okay. And have you had enough time to read through this document? Okay, and did you read it or did Mr. Haverco read it to you? Okay, and did he answer any questions that you have? Okay, and I'm gonna go over some high points of it, but there's paragraph 5 contains a number of constitutional rights. By pleading guilty, you're giving up those constitutional rights. You understand that? Okay, and did you discuss any potential immigration issues?
We did.
Okay. And Ms. Bose, this is a misdemeanor charge, which means the maximum penalty is 90 days in jail with a $1,000 fine. You understand that there's a recommendation contained with this, but I could sentence you up to the maximum? You understand that? Okay. And paragraph 11 states on September 22nd, 2025 in the city of Yelm while operating a motor vehicle, I was involved in a vehicular collision where the other vehicle sustained damage and then left the scene without first providing my license and insurance. Is that your statement? So how to the charge of hit and run, amended charge of hit and run unattended, how do you plead, guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily and no one's made any promises of any kind to cause you to enter the plea. I'll sign that order and hear from the city as it relates to conditions of the sentence or. Okay. Mr. Haverco?
She's really never been in virtually any trouble before, and
Right.
I think she just honestly kind of panicked a bit and didn't really, in a lot of ways, know what to do. And it's one of those things, if ignorance of the law was a defense, she'd probably have a defense, but
yeah,
it's just, so she's sorry it happened. And
did you, I mean, I'm just gonna ask, I know the insurance ticket's gonna be dismissed, but did you have insurance at the time? So you did. I got you. Okay, so it seems like any damages are being taken care of and et cetera. Okay. All right, Ms. Bose, what we'll do is this. I'm gonna follow the recommendation, just a little bit of a twist. Based on the fact that you have no.
I was
No,
gonna ask the court,
I'm gonna offer a deferred sentence for it.
I was really debating on whether to ask the court for that, but.
And so what I'm gonna do, Ms. Bose, is I'm gonna dismiss the no insurance ticket as discussed. On the failure to yield, I think it was 150.
Yeah.
Okay, gonna impose find that committed, $150 fine. And then on the hit and run unattended, what I'm gonna do is gonna impose 90 days, gonna suspend all 90 days for a period of 12 months. There'll be a $250 just probation monitoring fee on that. And you pay all the fines, you stay out of trouble. At the end of 12 months, this case will pop up. If you've done all those things, the charges will be, the guilty plea will be withdrawn and the matter will be dismissed. Sound fair? If you get in an accident again, don't hightail it out of there. Just, okay. All right. Okay, Ms. Bose, I'm going to sign this order. We'll give a copy at the window. And did you put deferred on there? Great, thank you. Okay. All right, Ms. Bose, I'm signing this order after you have, and then we'll be good to go. Thank you.
And so I was gonna tell you. All right, I've signed that order. Judge. Just talk to the clerk and get copies of your paperwork. Yeah, yeah. Yeah, no, take a look.
Take a look.
Yeah, yeah, okay.
I'm not familiar.
That's okay.
Thank you, Your Honor.
Thank you. Good luck to you.
Next matter is Chris Hurst.
Chris Ryan Hurst. All right, good morning, Mr. Hurst. This is cause number 5A09412448, controlled substance owning possession, use of drug paraphernalia with a tracking infraction. What are we doing with Mr. Hurst's case today?
Just one moment here. Go ahead and sign here. So he is going to enter a plea to count 2, the use of drug paraphernalia. Upon the court's acceptance of the plea, city will move to dismiss count 1.
Okay, you are Chris Hurst. All right, good morning, Mr. Hurst. I have a statement of defense on plea of guilty to cause use of drug paraphernalia under 5A09412448. Have you had enough time to read through this, or did Mr. Haverko read this to you, or both?
Both.
Okay, and have you had enough time to consult with him and have him answer all your questions? Okay. I have before me the plea to 1 charge. In exchange, if that plea is accepted, the city would be moving to dismiss a second count of controlled substance violation. Paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand that? And you understand that this is a misdemeanor, which means the maximum penalty is 90 days in jail with a $1,000 fine. There's a recommendation here. I don't have to follow. I could sentence you up to the maximum. Do you understand that? Okay. And Mr. Haverko, did you discuss any potential immigration issues?
We did.
Great. All right, Mr. Hurst, paragraph 11 states, on December 17th, 2025 in the city of Yelm, I possessed a pipe commonly known, according to Mr. Ratfield, as a bong. I had used for the purpose of smoking, consuming controlled substances. Is that correct? Is that your statement? As to the charge of use of drug paraphernalia, how do you plead, guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily. No one's made any threats of any kind to cause you to enter the plea, and I'll accept your plea. All right, I'll hear from the city in terms of sentencing.
Agreed recommendation, Your Honor.
Okay, Mr. Haverko, agreed. All right, Mr. Hurst, this is your opportunity. You don't have to say anything, but if you'd like to say anything before sentencing, it's your option. Okay. All right. Look at something here. All right, Mr. Hurst, I'm going to follow the recommendation. I'm going to dismiss cause number 5A09412448 on 5A09412448, count of use of drug paraphernalia. I'm going to find you guilty of that charge, impose 90 days in jail. I'm going to suspend all 90 days, going to impose a $1,000 fine, suspend $1,000 for a period of 12 months. Following conditions, law-abiding behavior, pay $250 in court costs, make all court hearings timely. Do you understand that? You got to answer out loud. Okay. All right. With that, I will sign this order and I wish you well, Mr. Hurst. Okay. Grab a copy at the window. Good luck to you.
Does the court want to do FTAs now or later?
Who do we?
This is our trial.
Okay, at noon. Yeah, let's do let me just whip through the the finish 10 o'clock. We have Megan Arlene Brown.
My notes reflect, I spoke with her either a week before court or a while back, and we were gonna do a plea. So I have had contact with her in the past. I don't have any information as to why she's not here today.
Okay. What's the city's thoughts?
Oh, let's have a warrant issued, 500 each.
Probably don't have any basis to object.
Yeah, let me just look at something real quickly. She's got no other warrants. You said $1,000 cash or bond on each?
500 each.
500 cash or bond on each. Okay. Next one's Jacob Moore.
My notes reflect, last time he had FTA'd and, if he showed up today, to either speak with him or try to get a new phone number, because I didn't have a number to call him. So I have no information.
DWS third, operating motor vehicle without ignition interlock. City's preference?
500 each.
500 cash or bond on each, please. And then last one on the 10 o'clock is Jeffrey Sanders. DWS first, no ignition interlock.
Same thing. He FTA'd last time around. I did have a phone number.
Can I ask a question? So if he FTA'd, how's he getting back on the docket? Okay. Okay. And he has an active warrant out of Fife for a DUI.
Had a phone number for him, called it, left a message for him to call me back, haven't received any return call.
Okay, what's the city's preference on this individual?
500 each.
Because he's got the warrant out of Fife, I'll go 1,000 on each on him. All right, 11 o'clock. Walter Chodakin.
Let's see.
Pretrial theft third.
This is a fellow who, when he was last in court, he either didn't have a number or he did, but he didn't know what it was. And so he was going to promise to email me or contact me and let me know what that number was. And I never heard from him. So I haven't had any way to have contact with him.
Okay. He's got a warrant out of Pierce County for an assault 4. He's got our theft. He's got has another subsequent theft that he pled guilty to in Lacey. Let me just see what that one is. I can't imagine he'd be in custody for. Let's see. Huh. Okay. What's city like?
500.
On Mr. Chodakin, all right, 500 cash or bond. And then Kirsten Landry.
I had a phone number that I was provided, but the number was no good. So I have not had a way of having contact.
Okay, Miss Landry has a warrant out of Olympia for theft. Has a warrant out of King County District for theft. That's an old one. Fair number of thefts. I mean, $1,000 cash or bond on Landry. She does? Who posted it? Okay, you want to send a notice, we'll forfeit the bond? Okay. Or notice of forfeiture. And then Elias Pettit.
So he FTA'd at his last appearance, I believe. And I was provided a phone number, but the number is no good. So I have not had contact.
DW's third, theft third, controlled substance possession ×2 with a paraphernalia and a no ignition interlock. $3,500. Okay, 500 on each, please. For Pettit, and then Carmen Velasquez Allende.
Yeah, and I have had contact with her in the past. I don't think I spoke with her a week prior to court, but I spoke with her maybe around her last court date. And I think we had agreed to do an SOC. And so I just had anticipated that she would be here. But she didn't contact me to let me know she wouldn't be here. So I don't have any.
Okay.
But I have spoken with her on the phone about her case, and so I kind of assumed she'd be here. I think on this one, maybe, I don't know, maybe she got confused or forgot about the date. I guess I'd consider asking the court to note the non-appearance and reset it with notice.
You have a good number for her though?
I do.
Okay.
Okay.
What city thoughts?
See the note here that she got the last hearing.
Yeah, let's.
I could just try to give her a call.
But we have a good phone number. So why don't we do it? What we'll do, we'll note the non-appearance one more time. And then I'll just put the burden on you to give her a call. And if not, just make a note that there'll be I'd recommend probably 2,500 cash or bond if she doesn't make it to the next one. Okay. All right.
Just for the court's information, so Megan Brown, who we've previously treated as an FTA.
Yeah.
On the 10 o'clock, she's here. She apparently had a transportation issue. She's here.
Okay.
If we could maybe take that up and.
Yeah.
Megan, why don't you come on up? Let me just get to the right spot.
Morning, Miss Brown.
Morning, sorry, I got a flat tire really here.
I appreciate it. And you can always call.
I did call.
Oh, you did? Okay, good. Okay. So yeah, all right, I see.
We're gonna proceed. Yeah, I'm gonna have her sign here in just a moment.
Okay.
Go ahead and sign this. Here. Great. Yeah, so we're proposing to enter a plea to the case ending in 935. On the court's acceptance of that plea, the city, as part of the agreement, will move to dismiss the other case ending in 887.
Is she on the 10 o'clock calendar?
She was, yeah, she's item numbers 4 and 5.
There we go. Okay. All right, you are Megan A. Brown. All right, Miss Brown, what's your highest level of education?
I graduated high school.
Okay. And I've got before me a statement of defense on plea of guilty. Did you read through this with Mr. Haverco, or did he read it to you, or both?
We read it together.
Okay, do you have enough time for him to answer any questions that you have?
Yes.
All right. I'm going to go over some of the highlights. So paragraph 5 contains a number of constitutional rights. If I accept your plea, you're giving up those rights. Do you understand that? Okay. And Mr. Haverco, did you discuss any potential immigration issues?
I did.
All right. And this is the charge you're pleading guilty to is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand there's a recommendation here. I don't have to follow. I could sentence you up to the maximum.
Yes,
Okay. All right. Paragraph 11 states that on September 21st, 2025 in the city of Yelm, I stole merchandise from Walmart. Is that true? Okay. As to the charge of theft, third degree alleged to have occurred on September 21st, 2025, how do you plead guilty or not guilty? Okay. Find your plea is made knowingly and voluntarily. No one's made any threats or promises of any kind to cause you to enter the plea. And I'll sign the statements. Are we moving to sentencing? We are. All right. Here from the city.
Your Honor, it's an agreed recommendation.
Okay. Mr. Haverco, I agree with that. All right, Ms. Brown, this is your opportunity to make a statement before sentencing. You don't have to make a statement if you choose not to, but it is your opportunity to let the court know here if you have anything you'd like to say. Okay. So I'm looking at your criminal history. You don't have a ton of thefts on your record. That's good. So was the merchandise that you tried to steal from the Walmart, was it returned?
Yeah, they ripped the bag off my
Okay, was it damaged, do you know? Was it returned at all? Okay. City, do we have anything to, okay, and no claim for restitution or anything? All right. All right, so Ms. Brown, I'm going to follow the recommendation. I'm going to dismiss the use of drug paraphernalia, which is cause number 580859887. And I'm going to find you guilty of the theft third charge under 580627935. I'm going to impose 364 days in jail. I'm going to suspend all 364. I'm going to impose $5,000 fine. I'm going to suspend $5,000 fine for a period of 12 months. Conditions are going to be as follows. You're to pay a $250 probation fee. During that period of time, you'll be able to set payments up at the window. You're to appear timely at all court hearings. You're not to have any criminal law violations. You're also not to go onto the property of Walmart. Do you understand that? Okay, so you're prohibited by them, by that company from going on their store. You're also prohibited by this court from going onto the store property, okay? All right. Anything else, either parties I missed?
Nothing else, Your Honor.
Okay, all right. Ms. Brown, good luck to you. Hopefully we won't see you again in here. All right. Okay.
You're not on.
12 o'clock.
It's $250. Then you go through the clerk. You'll have time to do it. You don't have to return. Just that. Okay, all right, take care. You're welcome. You too.
What's he charged with? He can waive his arraignment, just have him, he's here. What we'll do is he can waive his arraignment, we'll enter a plea not guilty on his behalf instead of a pretrial. Yeah, tell me, are you good, you comfortable doing that? Yeah, because it's a non-mandatory appearance. I gotta grab the 12 o'clock file. Does that make sense? Positive.
I was writing it at 12.
Apparently it worked. Right. All right, we're back on the record. This is the case City of Yelm versus Jason D. Shorts. Let me grab the cause number on that. This will be cause number 58030597. This matter is on for a non-jury bench trial today. My understanding is we've reached a resolution. Is that correct?
I think so. Yeah, I'm
Okay.
just trying to do the finishing touches here on, let's see, so
right.
data violation was 4.
Good morning, Mr. Shorts. All right, and I'll give Mr. Haverco just a second to craft whatever he's going to craft. There. So I've just placed into Oak Courts. If Oak Courts would work and not freeze my page. Okay, there we go. So I've just placed into Oak Courts a statement of defense on plea of guilty. I anticipate he's going to enter a guilty plea to the amended charge of reckless driving. We're doing it by way of an Alford plea combined with the principles as stated in re bar, because it's debatable whether or not he was in fact driving recklessly. Right.
And he also never really felt he was guilty of DUI. And, but nevertheless, the city has made an offer that's quite a generous offer, and he would like to take advantage of it. And, you know, he recognizes it's greatly to his advantage to do that. So, pursuant to the Alford plea, he agrees that while he doesn't necessarily agree he's guilty, we've reviewed the evidence pretty thoroughly. And he would agree that the evidence that's available to the city, along with whatever evidence Mr. Shorts has, were that presented to a finder of fact, whether it be a jury or a judge, that it's highly likely that a finding of guilt might be entered. And for that reason, he doesn't wish to contest those facts, and also wishes to take advantage of the city's plea offer. In addition to that, he stipulates to the principles as stated in re bar, that pursuant to the plea offer, he wishes to plead guilty to reckless driving, notwithstanding whether or not the facts support that charge.
All right, thank you. All right, Mr. Haverco, Mr. Ratfield, is the city making a motion?
Yes, city's moving to amend the.
Okay, all right. You are Jason Shorts. All right, good morning or good afternoon, Mr. Shorts. I have before me a statement of defense on plea of guilty to what is now an amended charge of reckless driving. Did you read through this, or did Mr. Haverco read it to you, or both? You feel like you've had enough time for you to go over this with Mr. Haverco and for him to answer all your questions? Okay. Paragraph 5 of this document contains a number of constitutional rights that you understand if I accept your plea, you're giving up. And have you had a chance to discuss any potential immigration issues, Mr. Haverco?
Yes.
All right. So, Mr. Shorts, based on the statements of Mr. Haverco, I'm going to review the police reports and a factual basis for the plea. Understanding that if I accept this form of the plea, as was referred to as an Alfred Newton type plea, it is a finding of guilty. It's a plea of guilty. It's treated the same as a traditional plea of guilty, just so you understand. Okay. Okay, based on my review of the police reports, I find the evidence is more than sufficient to justify a finding of guilty in this case. I think that the facts that would be provided through a trial or any other evidentiary based hearing in this case would meet proof necessary beyond a reasonable doubt for Mr. Shorts to be determined guilty of the charge of what is otherwise would potentially be a DUI, but in this case is a reckless driving. I also recognize the in-rate bar aspect of this, that Mr. Shorts is agreeing to accept some loosely interpreted elements in order to take advantage of a favorable plea offer. So based on that, Mr. Shorts, I'm going to I'm going to find you guilty of the charge of reckless driving alleged to have occurred on or about, I think it was September.
April
April
12th.
12th of 2025. All right. So I'll sign the judgment and sentence, or the statement of intent on plea of guilty, find it's entered into knowingly and voluntarily. No threats were made to cause Mr. Shorts to enter the plea. And we will proceed accordingly. Okay. All right, I'll hear from the city.
Your Honor, it's an agreed recommendation.
Okay, Mr. Haverko.
It's agreed, Your Honor. You know, it's one of those things, the parties have kind of had a lot of back and forth, a lot of negotiation, and I think this is a good decision on Mr. Short's part. I think this amendment is to his benefit, and I'm glad that, but notwithstanding the Alfred plea, I'm glad that he's settling the matter, because I think that's still to his advantage.
Okay.
I'd ask the court to consider imposing the suspended jail time. It's a year in jail, all suspended. It's not in the plea form, but we agreed to all of what would be the typical DUI conditions, assuming the court's going to not recommend, but rather order an alcohol evaluation, show proof within the 90 days, comply with any recommended treatment, that the court would order a victim impact panel, and again, all of the other kind of standard DUI related conditions. So Mr. Shorts would anticipate that the court would likely be ordering those things on this sort of case.
Okay, and I accidentally signed the judgment sentence, so I might make some changes. All right, Mr. Shorts, this is your opportunity to state anything in the court you'd like to state before sentencing. You don't have to say anything, but it's your option. Okay. All right, so I looked at your history, Mr. Shorts, and you haven't had anything in 20 years. Your history outside of 20 years is there were some things going on. It looks like that you maybe got taken care of that long ago. But when I reviewed the police reports here, a couple things stood out. Number one, the PBT, the portable breath test was alleged to be 182. And in the police reports, it was alleged that you stated, and I'm not engaging you to object to this or argue with me about this, but I'm saying, you said you had diabetes, and you said that your diabetes and your interpretation would affect your alcohol level. Diabetes doesn't work that way. What diabetes does is it gives like somebody could walk in and be stumbling or be their speech slurred, and somebody might interpret that as somebody being under the influence, when in fact it's a diabetes issue. You refused the breath test. We had the PBT, so we don't have the formal breath test process. As you know, the city could use the refusal against you had this gone to bench trial. So based on the driving, based on everything else, if you really don't think you were under the influence, I mean, you denied drinking at all in this incident, I just don't buy it. I could see you saying, well, I don't think I was under the influence, but your position in this at the time of the stop was you'd had nothing to drink and all of that. I don't buy it. That's a fiction to me. I am going to note you've gone 20 years without any criminal history, which I think is fantastic. I'm going to interpret this as a glitch or a setback that I'm hoping you're going to do everything you can to get taken care of, and so that it doesn't happen again. So with that, I'm going to generally follow the recommendation. I'm going to impose 364 days in jail. I'm going to suspend all 364. I'm going to make jurisdiction for 24 months instead of 12. So the suspended jail time is going to hang over your head for 2 years. Following conditions, I'm going to impose $5,000 fine. I'm going to suspend $500. I'm going to ask the city, Mr. Haverko, you can object to this if you choose, but I'm going to ask the city if the offer that was accepted today was made today, or was it made weeks, months ago? Are you okay with me asking that question?
The city made the offer yesterday.
Okay,
Okay.
okay,
And I put out a message.
okay, I get it. No, my question,
Yeah, so no, this offer was not on the table.
Okay. Okay.
And the defendant waited. No, I mean.
Yeah,
we just learned about
okay.
it today.
And the reason that is, Mr. Shorts, just for full transparency of my thoughts, is we have an officer here, at least one, maybe two. And if I start sensing that people are, refusing offers that are probably very reasonable offers, and then sort of pushing the city up to a trial for the sake of trying to get a better offer, I would be more inclined to impose the costs that the city has to absorb with the cost of the officers to show up and things of that nature. But because of the offer was made yesterday, I'm not going to go above and beyond the probation monitoring fee that's been requested of $250. You are to not have any criminal law violations. You're to appear timely at all scheduled court hearings. I'm going to order you not to drive without a valid license and liability insurance. You're not to drive or be in physical control of a motor vehicle with an alcohol concentration of 0.08 or higher, or a THC concentration of 5 nanograms per milliliter of whole blood or higher within 2 hours of driving. In order you're not to have any alcohol-related infractions. You're not to refuse to submit to a breath test or blood test upon the request of law enforcement, the court, probation, or any treatment provider. I'm going to order you to comply with all of the rules and regulations related to ignition interlocks that the Department of Licensing may require. We had a pretrial ignition interlock requirement. We can lift that. So now it'll just be whatever DOL requires is what you're going to be required to do. You'll be on monitored probation for the 24 months, as we discussed. You're to obtain an alcohol drug evaluation and complete any required treatment. I'm going to have you do that within 60 days of today's date. And you're also to complete the victim's impact panel. Again, that's within 60 days. Anything from the city that you think I missed?
No, Your Honor.
Mr. Haverko?
Nothing right.
Okay. All right, Mr. Shorts, you're going to get a copy of this order at the window. Do the eval, do the victim's impact panel. If you do those classes and you don't send proof in, we don't know you did it. So make sure you send it in. All right. Wish you best of luck. Okay. Copy will be at the window. Good luck to you.
Is a Mr. Nathan Benavides in the courtroom? I think I saw you wave your hand. Yeah, I'm seeing you wave your hand. Okay. Yep. Good to see you.
All right, we're back on the record. This is the afternoon calendar for Yelm Municipal Court. Have a couple matters ready. We'll take the Klitsch matter first. City of Yelm versus Richard Klitsch.
Your Honor, citizen dismissed.
Okay. That was easy. Okay. Yeah. You just made a sign that or initial that too. Okay. If it doesn't work, let me know. All right. Okay, so let me get one here really quickly. What's that? Yes, I think so. I'm gonna look, that's what I'm looking right now. Is there gonna be an order of dismissal? There is, okay. I'm not seeing it yet on Klitsch. No order came through on Klitsch. Oh, there we go. Got it. Yep, it's there now. Okay, on the City of Yelm versus Richard Lee Klitsch. Cause number 680010622. On the city's motion, this matter will be dismissed with or without prejudice. Okay. All right, let's take the City of Yelm versus Mark Diaz. Go ahead. Good afternoon. Good afternoon, Mr. Diaz. You're here for cause number 680097585. Mr. Russ, this is on for Raymond DUI. I'll turn it over to you.
And Your Honor, we'll acknowledge receipt of the citation, waive any formal reading, enter a not guilty plea, did discuss my client's rights as well as the ranges for a DUI with him. We'll reserve any arguments on probable cause at this time.
Okay, thank you. So Mr. Diaz, based on the statements of counsel, we're going to waive further reading, further advisement of rights. We're going to enter a plea of not guilty on your behalf. We're going to stipulate your lawyers stipulated probable cause for purposes of this hearing only, so that issue can be raised at a later time if necessary. So I'm now going to turn to the city for conditions of release. I'm looking at Mr. Diaz. He's got a prior from 2013 and then a couple before, one in 2010. Okay. All right. Standard conditions are going to be standard conditions plus ignition interlock. Any objection?
Just to be clear, what are the standard conditions in the
Standard, no law violations, no consumption, no bars, taverns. There'll be a pretrial ignition interlock order. Those.
Understood.
Yeah.
No objection.
Okay. All right. So Mr. Diaz, I'm going to fill out this order. Conditions, no criminal law violations. This is all pretrial. Pure timely at all court hearings. Keep your address and name and everything up to date with court. No drive without valid license and liability insurance. Don't be in physical control of a motor vehicle after consuming any alcohol. You're not to have any alcohol-related infractions. Not to refuse to submit to a breath test or blood test upon request of law enforcement, court, or with probation or treatment provider. And again, you're not to possess any alcohol or non-prescribed drugs. There will be, and you're not to go to a bar or tavern. You're not to operate a motor vehicle without an ignition interlock installed. We'll give you 5 days to do that. And when that's installed, you'll provide proof to the court. And we'll give you an out of custody retained counsel court area. March 12th or March 26th?
Let me just double check, Your Honor. March 26th would be great.
Okay. That'd be 9 a.m. Yeah, March 26th at 9 a.m. will be your next court hearing. Stay in touch with your counsel, and we'll see you back here March 26th at 9 a.m. Is that all your cases today?
It is, Your Honor.
All right.
Thank you.
Sign the order. A copy will be at the window.
You sign on this pad. It might not show. Is his signature coming through on the pad?
Yeah.
Oh, he signs at the, okay. Thank you, everybody.
All right, thank you. Nathan who? Which number on the docket? Okay. Gotcha. Okay. All right, Mr. Holcomb, are you out there?
Yes, Your Honor.
Nathan Benavides? Benavides, let's come forward, Mr. Benavides. This is cause number 6, City of Yelm versus Nathan Benavides, cause number 680061883. Mr. Benavides is present, represented by Mr. Holcomb, who is present via Zoom. This matter's on for arraignment. Mr. Holcomb.
Yes, Your Honor. Thank you. We'd like to acknowledge receipt of the complaint. We're stipulating to probable cause in this place, and we would like to enter a plea of not guilty at this time.
Okay. All right, Mr. Benavides, based on your statements of counsel, I'm going to waive further reading of an advisement of rights. We're going to stipulate the probable cause for purposes of this hearing only, and we're going to enter a plea of not guilty on your behalf. Now going to turn to the city for conditions of release. So on the judgment sense, it's coming up as driver's license number. Are we going to leave that?
Yeah.
For now? Okay. 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 All right. Okay. I'll hear from conditions of release. Okay. Mr. Holcomb, standard conditions. Any history here?
There's no history, Your Honor.
Okay, Mr. Benavides, you're going to be released on your own recognizance under the following conditions. You're not to commit a criminal law or criminal traffic violations. You're to appear timely at all court hearings. Keep your address and everything up to speed with the court and Department of Licensing. Don't drive without valid license and proof of insurance. No alcohol. No consumption of any alcohol, and not to refuse a blood test or breath test if asked by law enforcement, the court, or probation or any treatment provider. Also not to go in a bar or tavern. Do you understand those conditions? Okay. Give you out of custody. When do we do? March 26th or March 12th? March 26th or March 12th, Mr. Holcomb?
Your Honor, firstly, I just have a couple of things to point out to the court. Firstly, my client is scheduled to leave the state on March 1st. He's currently serves in the military, and he's going to be stationed out in Georgia. So part of this is just, does my client, is he able to appear on Zoom for hearings? And what is this?
Yeah, I will authorize that.
And is that also permitted for disposition hearings as well?
What's the city's thoughts on that?
No issues.
Yeah, under those circumstances, I think we can do that.
Understood. So the March 26th date, I believe, was the court date that was offered.
Yeah, at 9 a.m.
Yeah, the state would, defense would ask for the March 26th date at 9 a.m.
And it shall be that. Okay, Mr. Benavides, we're gonna release, you're gonna get a copy of this at the window. I am gonna authorize Zoom participation on your part, okay? Stay in touch with Mr. Holcomb's office and comply with the conditions. We'll see you back here on March 26th or via Zoom at 9 a.m. Okay, thank you. Okay.
Thank you, Your Honor.
Thank you. Take care, Mr. Holcomb. Any other attorneys? Okay. 36. Darren Vogel present. Good afternoon, Mr. Vogel. We have, is it Arsenault?
Yes, that's correct. I'm standing in for Miss Bowden this afternoon.
Thank you. Good afternoon, Mr. Arsenault. We are here on the Darren James, City of Yelm versus Darren James Vogel, cause number 6A00100635. Mr. Vogel's present, out of custody, represented by counsel via Zoom. I'll turn it over to you. It's on for arraignment, so I'll turn it over to you.
Thank you, Your Honor. My client has been made aware of his constitutional rights at arraignment, and he understands those rights. He understands the nature of the charges being presented here today. We'll stipulate probable cause for purposes of this hearing, enter a plea of not guilty, and we would ask for standard release conditions and set for pretrial.
All right, thank you. So good afternoon, Mr. Vogel. So based on the statements of counsel, we're going to waive further advisement, reading and further advisement of rights. We're going to stipulate the probable cause for purposes of this hearing only, and the city will be entering a plea of not guilty on your behalf to the charge of DUI. Turn it to the city for conditions of release.
Standard, Your Honor.
All right, standard conditions. Any objection to those standard conditions, Mr. Arsenault?
No, Your Honor.
All right, Mr. Vogel, if you've been sitting here for a little bit, you heard the kind of the standard conditions or what they are. Basically, appear at all court hearings, no criminal law violations, keep your address and name and everything up to date with the court. Don't drive without valid license or proof of liability insurance. Going to order you to have not possessed or consumed any alcohol or non-prescribed drugs. You're not to refuse any alcohol or drug test upon the court, probation, or treatment provider. Not to operate a motor vehicle with a 0.08 alcohol level or 5 nanograms per milliliter of whole blood. You're not to enter any bar or tavern. And those will be the conditions. So we'll need an out of custody pretrial date. Are we still looking at the 26th? Proposed date is March 26th at 9 a.m. How does that work?
That should be fine, Your Honor.
Okay. So March 26th at 9 a.m. will be your next court date. Stay in touch with your counsel and we will go from there. Okay. All right. Anything else, Mr. Arsenault?
No, not today, Your Honor. Thank you very much.
Have a good rest of your day, Mr. Vogel. The copy of this will be at the window.
Thank you, Your Honor. Have a good day.
Thank you. You too. Okay. Any more attorneys? No? Okay. All right, folks. Thank you for your patience. We are here on the arraignment calendar. I need to look at one thing. Okay, is there a Tristan Wayland Roberts present? Why don't you come forward? All right, Mr. Roberts, reason I'm calling you forward is you were charged with driving a suspended license, 3rd degree. I'm looking at your oh wait, looking at your record right now. It looks like you're licensed. The city's thoughts. Okay, so because you're relicensed, city's going to make a motion to dismiss. Okay, so I'll sign an order. There'll be a copy for you at the window. Okay, thank you for coming in. All right. So that's going to be just a dismissal. Okay, let's sign it. Okay, sign the order. Okay, now, ladies and gentlemen, the rest of you are here for arraignments. I'm gonna call some names for some folks that are also here for driving with suspended license, third degree charges. This court and the prosecutor, more importantly, the prosecutor has a standing process where if you are charged with if you're arrested and only charged with a driving with license suspended third degree and no other significant charges, the city makes a standing motion to amend that charge to a no valid operating license with ID. The fine amount will be $150, but the city moves or amends the criminal case to an infraction. Okay? Now, you don't get to argue that. That's what's going to happen. If you want to deal with it, if you want to contest that or whatever, you can do it at the window. But what I'm going to do is if I call your name, I'm going to ask you to go out and then I'm going to have you go to the window to the left and line up and the court clerk will have the paperwork and you can either coordinate paying the $150 or however you want to deal with it. Okay? All right. So I'm going to start with the first name I think is eligible would be Christopher Garwood. Is there a Christopher Garwood present? No response. Stephen Hand. Mr. Hand, come forward. So Mr. Hand, I'm gonna have you go out to the window. And again, your case would be automatically amended to I still recommend anybody who comes up gets licensed, but it'll be amended to an infraction. Okay, so I'll let you go out to the front window. The next matter will be, is there a Cassandra Kenny present? Cassandra Kenny? Okay, let me get that one. Let me do this one. Tristan Norton. All right, Mr. Norton, come forward. Yours is a little different. You've got two ones that are, so you can stay right there. We're gonna amend the DWS third to a no vol with ID at $150. And what does the city do with the failure to transfer title?
City's not gonna dismiss, but it will lower to 150.
Right, be lower to $150. Okay, let's go to the window. Thank you. Get licensed. Eric Olson. Heather Poynton, are you Eric Olson? Oh, sorry. Okay, Mr. Olson, have you go out there to the window. Heather Poynton, Ms. Poynton, we're gonna go to the window line. They'll amend it to a no vol with ID, $150. Okay. Ann Rankin. Ms. Rankin, same thing. Thank you. Carly Rose. Let's see. Leandra Samoa Santos. Okay. James Skelly. Let's see. Stephen Wengeleski, third. Okay. Karen Whitaker. Miriam Whitman. Okay, Ms. Whitman, I'll have you go to the window. So we did hear did you just get here? Okay, so you're gonna get in line here. Your case will be amended to an infraction with a $150 penalty. You can contest it at the window if you so choose. Okay. Corey Wilson. Mr. Wilson, this is a no valid operating license without identification. Yours will be amended to a with identification, which is an infraction, $150. Okay. Jared Wilson. And last but not least, Alicia Wright. Okay, Ms. Wright, you are the last one for today, so I'll have you go get in line at the window and. Yep, thank you. Okay, now what we're gonna do is I'm gonna go through the calendar. The rest of you folks here are here for the arraignment calendar represented. We do have a public defender present. I'll just start at the top. First matter I'll call is City of Yelm versus Jessica Alexander. No response. Next case is City of Yelm versus Christine Avery. So Avery, why don't you come have a seat up there next to Mr. Haverco. This is City of Yelm versus Christine Avery, cause number 6A00412777. Miss Avery is present. We're here for arraignment. Mr. Haverco, I'll have you inquire. Yep.
Monthly income is $600.
Okay. All right, Ms. Avery, I'm going to find you eligible for court-appointed counsel, and I'll turn it over to Mr. Haverco for arraignment purposes.
Stipulate to probable cause, ask the court to enter not guilty plea.
Okay. Ms. Avery, what I'm going to do is waive formal reading of any additional rights, find probable cause purposes hearing only, and ask that a plea of not guilty is going to be entered. Hear from the city in terms of conditions of release.
Standard conditions, Your Honor.
Yep. Where was it at? Was this Walmart case? Thank you. All right. Oh, sorry. I have to plug it in. Sorry about that. So Ms. Avery, you're going to be released under the following conditions. You're to appear timely at all court hearings, not commit any criminal law or criminal traffic violations, and you're not to go onto or have any contact with the Walmart. Do you understand that? Okay. Next court date is going to be March 26th at 10 a.m. You're going to be given information on how to contact Mr. Haverco. Reach out to him, make sure he has a good number for you as well. Okay. Then if you do get around a phone, reach out to him if you haven't heard from him. Okay. All righty. Okay. I've signed the order. Good luck, Miss Avery. See you back here on the 26th. And again, unfortunately, you got to get in that line and get you a copy of this order. Yep. Next matter, Michael Cantrell. Let's come on forward.
Public assistance, Your Honor.
Okay. All right. I'm going to appoint Mr. Haverco for purposes moving forward. Go ahead.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Okay. All right, Mr. Cantrell, we're going to waive formal reading and we're going to find probable cause purposes hearing only and enter a plea of not guilty to the charge of controlled substance knowing possession. Now I'm going to hear from the city in terms of release conditions.
Your Honor, it's going to be standard.
Okay. Standard conditions, assuming no objection from Mr. Haverco, you're going to be released on your own recognizance. Conditions are going to be no law violations, appear timely at court hearings, keep your address and everything up to speed with the court. Do you understand those things, Mr. Cantrell? Okay. Going to be given information on how to contact Mr. Haverco. Make sure he has good information for you. And your next court date is going to be March 26th at 10 a.m. Okay. All right. We'll see you then. Okay, free to go. You too. All right. Gabriel Cesaneros Castro. Okay. All right. And is it Cesaneros Castro? Yes, sir. All right. Good afternoon. City of Yelm versus Gabriel Cesaneros Castro, cause number 680015693. Charges hit and run attended. Mr. Haverco.
It comes about 2,000 a month.
Okay. Find you eligible for court-appointed counsel at no cost to you. Turn over to you, Mr. Haverco.
Stipulate to probable cause, ask the court to enter not guilty plea.
Okay. All right. Conditions of release.
PR, Your Honor.
Okay. All right. Mr. Cesaneros Castro entered a plea of not guilty on your behalf, found probable cause purposes hearing only. Going to release you on the following conditions: appear at all timely at all court hearings, no criminal law violations, keep your address and everything up to date with the DOL. I'm also going to indicate you're not to drive or operate a motor vehicle without valid license and proof of liability insurance. Going to give you out of custody court hearing March 26th at 10 a.m. You'll be given information from Mr. Haverco. Make sure he has good information for you. Okay? So see you back here March 26th at 10 a.m. Thank you. Free to go. William Dorsey.
He's here somewhere.
Good afternoon, Mr. Dorsey. This is cause number 680097587. Mr. Dorsey's present. This is a charge of criminal trespass in the second degree. Mr. Haverco.
I have represented Mr. Dorsey before, and he was indigent at that time. I do not think his circumstances have changed.
Okay. All right, Mr. Dorsey, I'm going to appoint Mr. Haverco for purposes of this hearing. I'll turn it over to Mr. Haverco.
Stipulate to probable cause, ask the court to enter not guilty plea.
All right. Mr. Dorsey, based on statements of counsel, I'm going to find probable cause for purposes of this hearing only, enter plea of not guilty. I'm going to turn my attention to the city for conditions of release.
Your Honor, the city's just going to ask for standard conditions, and obviously Mr. Dorsey not returning to the trespassed area.
And I want to look at something here. So the January 23rd, which is this one we're dealing with. Involved the Yelm Middle School. And we have another one from January 2nd. All right. it looks like it's a different area. So Mr. Dorsey has, problem I'm having, Mr. Dorsey, is this: you're on conditions of release for criminal trespass from November 19th. It's still open. Let me look at that one. Nisqually Plaza. Then you're on another one for the one from January, which is January 2nd, which a little unclear what that property was. And then the third one is you were at the middle school. You've been on conditions of release for those two, for one of them since November, this last one probably for a couple weeks. And we're still running into issues with you being arrested for trespassing. Are you aware of are you aware in this town where you can't go? Do you know where you've been trespassed from? You're trespassed. Yeah. So you're telling me you're aware of where you're trespassed from. Okay, what I'd like to do is reset. I'll release him on his own recognizance, but I'm going to set this, set it in the normal course. You're telling me on the record, you know where you're trespassed from. If you have another trespass, I'm going to take you into custody because you're going to leave me no choice because you're violating the conditions of release. Do you understand that? Okay. All right. So we'll set, this is the last strike, so to speak. So, and I don't want to do that. And I understand you're in a tough situation, but these private entities in this town and some of the public entities have the ability and the authority to tell you not to come there for whatever reason. And this court, this city, the prosecutor, we have to enforce those rules. And I'm going to start enforcing those rules if you keep doing this. Okay, I want to give you fair warning. So next court date is going to be March 12th, 2026 at 10 a.m. You're to comply with all the previous court orders. You're not to go to the Nisqually Plaza. You're not to go to the Yelm Middle School. You know the other places you're not supposed to go to. No criminal law violations. And we will make all your court hearings, and we'll see you back here on March 12th. Do you have a phone or anything like that?
You don't have a phone.
You make sure Mr. Haverco has your phone number? Okay. All right, next court date is going to be March 12th, 2026 at 10 a.m. And then I'll sign that order when it's ready. Okay. What's that?
Showing you is still editing. Is it?
Now mine's not showing you as editing right now. Okay, yeah, it looks like it's right. Okay. All right, I'll sign the order. Mr. Dorsey, good luck to you. Okay? All righty. Okay, that's all for today.
Wait a second, Mr. Dorsey. 1 second.
Stephen Fawcett.
Mr. Dorsey to sign here on this pad. Okay. There you go.
All right, this is City of Yelm versus Stephen Fawcett, 6A0006652. Mr. Fawcett's present, out of custody, DUI. Go ahead and have a seat. Thank you. Mr. Haverko, I'll have you inquire.
What do you make for child support?
In
Take home?
Yeah, in averages,
because I
do catering, so it fluctuates.
So before child support, about 2,100 to 2,300 a month. After child support, about 1,700.
Okay, I'll find Mr. Fawcett's eligible for court-appointed counsel at no cost to him, so I'll turn over to you, Mr. Haverko.
Stipulate probable cause, ask the court to enter not guilty plea. Do you have a phone number? 515 8988.
Yes, sir. Okay, Mr. Fawcett, I'm going to find probable cause purposes hearing only, enter plea of not guilty. Hear from the city in terms of conditions of release.
Standard conditions, Your Honor.
Mr. Haverko?
No objection.
Okay, so Mr. Fawcett, you have a prior DUI that was amended to a neg one about 5 years ago?
Yes.
And so based on that, the conditions are a little bit modified. I am going to release you on your own recognizance. Following conditions, you're to appear timely at all court hearings. You're not to commit any criminal law or criminal traffic violations, not to drive without valid license, proof of insurance, not to be in physical, not to consume any alcohol, not to refuse any alcohol or drug test. You're not to go to any bars or taverns. You're not to have any alcohol-related offenses. You're not to drive with alcohol concentration of 0.08 or more, obviously, or a THC concentration of 5 nanograms for higher. You're not to go to any bars or taverns, as I said. You're also going to be required to have an ignition interlock in any vehicle you drive pre-trial, and that'll be, you'll need to provide proof of that to the court within 5 days. Okay, going to get a copy of this. Next court date's going to be March 26th at 11 a.m. Make sure Mr. Haverko has your contact information, and we'll see you back here on March 26th.
How do I get in touch with the
Mr. Haverko may have some secret places to go for that. I have no idea. Otherwise, you just gotta, there's a bunch of companies that provide it. You shop around.
Yeah, there might, the clerk also might have some information at the counter.
Okay, thank you very much.
Yeah.
All right, good luck to you. We'll see you back here on the 26th. Next case is Amanda Frank. Why don't you come forward, Ms. Frank? This is City of Yelm versus Amanda Frank, cause number 680089678. Ms. Frank is present with counsel. Mr. Haverko, I'll have you inquire.
She just started her own salon business. So
Okay.
she's making around 2,000 a month at the moment. I'm sure she hopes it
Yeah,
does better in the long run.
okay. All right. Ms. Frank, I'll find you eligible for court-appointed counsel at no cost to you, so I'll turn it over to Mr. Haverko.
Stipulate the probable cause, ask the court to enter not guilty plea.
All right.
Okay, phone number?
Find probable cause, stipulate for purposes of hearing only, enter plea of not guilty. Ms. Frank, I'm not, and I'll turn from the city. I don't see any history. Okay. Ms. Frank, we're going to release you on your own recognizance. You have no prior criminal history. Following conditions are going to apply. You're to appear timely at all court hearings. You're not to have any criminal law or criminal traffic violations. Not to operate a motor vehicle without with a valid license and proof of liability insurance. You're not to have any alcohol-related infractions. You're not to refuse to submit to any breath test or blood test if ordered to do so by law enforcement, court, or probation or a treatment provider. Not to use or possess any alcohol or non-prescribed drugs, and you're not to enter any bar or tavern. Do you understand that? Okay, those conditions are pretrial conditions, all right? I'm going to give you out of custody court date of March 26th at 10 a.m. I saw you exchanging information with Mr. Haverko. So if we can just make sure you stay in touch with him, don't call him on March 25th and call him well before then, and he'll be able to walk you through this process. Okay. All right. Okay. Anything else on Ms. Frank's matter?
No.
All right. Ms. Frank, good luck to you. We'll see you back here on the 26th. Next matter is Victor Gutierrez Martinez. No response. Daniel Hamilton. Daniel Hamilton. No response. Dallas Hazelrig. No response. David Kistel. All right, come on forward, Mr. Kistel. Okay, this is David Ivan Kistel, cause number, City of Yelm versus David Ivan Kistel, cause number 680010628. Mr. Kistel is present. Out of custody, charges driving with suspended license, first degree. Mr. Haverco.
Well, it looks like there's an order in Oak Courts that someone put there.
I don't know. Let me take a look. Is it a good order or bad order?
I haven't looked at it.
Oh. Appears to be an order of dismissal.
You know what? That must have been where my order for Klitsch went earlier. They're right next to each other.
It's being trashed.
Got it. Do you work? Do you have a job?
I'm currently.
How do you survive?
Just my situation right now.
I mean, how do you survive?
I used to be employed, I used to be a massage therapist.
Oh, gotcha. Currently unemployed, Your Honor.
Okay. All right, Mr. Kistel, I'm going to find you eligible for court-appointed counsel and appoint Mr. Haverco as such.
Stipulate the probable cause, Your Honor. Ask the court to enter not guilty plea.
Thank you. Going to enter plea of not guilty. Find probable cause purposes hearing only. Turn it over to the city for conditions of release.
Standard, Your Honor.
Okay.
4740.
So, Mr. Kistel, you're not to be driving. Okay. I'm going to release you on your own recognizance. Main conditions, no law violations, no criminal law violations. You're not to drive without a valid license and liability insurance. You understand that? Okay. So if you get caught driving, that'll be a problem. All right. I'm gonna.
He doesn't want to look at it right now.
Yeah. Going to appoint Mr. Haverco. You and he have exchanged information. The next court date's March 26th at 11 a.m. And stay in touch with him, and hopefully we'll get this case. Hopefully, I'd again work with Mr. Haverco. Hopefully, get this case resolved. Good luck.
You can have a seat for now, and I'll catch you when I'm done with court. Yeah.
Next one is City versus Mark McCoy. There's a letter in the file. Looks like Mr. McCoy is currently hospitalized, so there's no discharge date. He was admitted on 1/21. So do we want to just reset it out about a month for arraignment? Okay. Next matter is Damian Martinez Pisano. No response. Amanda Redenkop. No response. Wendy Sassone. No response. Zachary Sawaya. Let's come forward, Mr. Sawaya. All right, this is City of Yelm versus Zachary Sawaya, 680101927. Mr. Sawaya is present, out of custody. Mr. Haverco, if you can inquire.
He's still unemployed from last time I represented him.
Okay. All right, I'll go ahead and appoint Mr. Haverco moving forward. I'll turn it over to you.
Stipulate the probable cause as support to enter not guilty plea.
Okay, wait for the reading, stipulate the probable cause for this hearing only and enter plea of not guilty to the charge of malicious mischief third degree. Hear from the city in terms of conditions of release.
PR, Your Honor.
Okay. PR release standard conditions, Mr. Sawaya, are going to be make all your court dates timely, no criminal law violations, stay in touch with your attorney.
Got phone number, cell phone or anything? 515. Mr. Haverco, these events, it looks like these events occurred at the 15499 Chad Drive Southeast. Is that where Mr. Sawai is residing or not? City have any thoughts on restricting Mr. Sawai from that address?
Not if he's residing there.
All right. So, Mr. Sawaya, the allegations here are a malicious mischief charge, okay? Whether they're true or not, I don't know. I know it's in the police reports. And the problem is they occurred where you're living. I'm assuming the other parties that are mentioned in this police report are also residing there. They're not, okay.
I don't know if I'm allowed to say.
Well, I wouldn't say anything. I'm just gonna tell you, to make sure there's no issues while you're on pretrial release, okay? All right. So standard conditions as discussed. March 26th, 10 a.m. is your next court hearing. Stay in touch with Mr. Haverco, and we'll see you back then. Thank you. Sign that order. Okay. Christine St. Marie. Oh, Sydney Christine St. Marie. Sorry about that. All right, this is City of Yelm versus Sydney Christine St. Marie, cause number 680010626. Miss St. Marie is present for purposes of right now with Mr. Haverco. She's out of custody, charges DWS third and operating motor vehicle without ignition interlock. Mr. Haverco. She's a stay-at-home mom on public assistance. Okay, I'll appoint Mr. Haverco moving forward, and I'll turn him over now for arraignment. Stipulate probable cause, that's court or not guilty plea. Okay. Ms. St. Marie, I'm gonna find probable cause, at least stipulate the probable cause purposes hearing only. We are going to enter a plea of not guilty on your behalf, standard conditions from the city. You are to appear at all court hearings, no criminal law violations, do not drive without valid license and insurance. You understand that? Okay. Stay in touch with Mr. Haverco, make sure he's got your contact info. You are to comply with Department of Licensing rules and requirements regarding ignition interlocks. Okay? Next court date is going to be March 26th at 11 a.m. And we will see you back here at that time. To the window, get a copy of this order. Yes, ma'am. Thank you. Okay. And then Jamie Stevens. No response. So you want to I'll whip through these warrants really quickly. Let me get back to square one. First one will be Jessica Alexander. Theft third. $500 cash or bond, non-appearance. Gabriel Castro Ceniceros. Oh, he was here. He was here. Yep, sorry. Victor Gutierrez Martinez. DWS second degree.
Gutierrez Martinez.
Gutierrez Martinez, yep.
Do we, that we noticed in
Oh, yep. Okay, reset with notice, 30 days. Daniel Hamilton, DWS third, but that one should have been taken. Oh, he's at and a controlled substance. I'm okay with that. He has no warrant history. Reset 1 month? Yeah, let's reset on 1 month. Hey, he tried. Dallas Hazelrig. $500 cash or bond on each. Damian Martinez Pisano. Martinez Pisano. Okay. 500 on each charge. Amanda Redicop. Okay. Okay, kicking it a month? We'll kick that a month. Wendy Sassone. $500 cash or bond. We dealt with Sawaya. We dealt with Sydney St. Marie. Jamie Stevens. 500 cash or bond. All right, I think that concludes the calendar. Ma'am? Ma'am, what's your name? Let's see. Are you here for court?
No, I'm just, sitting in for
Oh, okay, great. All right, well, we're gonna pull some matters. We've got some lawyers online, so I will get pulling those first. All right.
Good afternoon.
Good afternoon, Mr. Scow. How are you?
Life is good.
Good. Okay, who have you got?
I have two matters, starting with Lincoln Kikuo, Kikuo.
Okay, the cause number 5A, are we on the record? 5A 0750866, Lincoln Kikuo. Mr. Scow is, this is a contested hearing, allegation of speeding and no insurance.
And for the record, Matthew Scow, Roberto Irnella's office for Mr. Kikuo today. This is a defense request for a continuance. We're still trying to get some insurance documentation from him for that count too. We'll waive speedy for purposes of the request.
Okay, no objection. So we'll go ahead and just give you one another 30 days.
Sounds about good.
Okay, let's set it out 30 days. Okay.
Thank you, Your Honor. My next matter is Davian McQueen, McQueen.
Davian McQueen, cause number 5A0700180. I've got that. It's a speeding 15 over obligation.
Your Honor, I have a motion to suppress evidence of speed for failure to provide sufficient foundation for the accuracy of the speed measuring device. In the officer's narrative, we get to the section where he's talking about checking the speed measuring device, and it's all in the passive voice. He says unit was checked. He never indicates who did the checking. No indication as to whether the officer checked it or the officer has any personal knowledge. Now, that might not normally be a big deal, except that the officer also seems to reference someone else as the operator of the SMD device. Earlier in the narrative, he says the operator was absolutely certain that the radar was indicating the defendant's speed. And considering everything else in the report is in the first person, I'm not sure if he's implying that there was a second person in the car operating the device with them or not, or if it's just really weird syntax. But each of these things individually and accumulatively seem to cast some doubt as to the accuracy of the SMD device.
Okay, we'll go ahead and dismiss the infraction. It's no lack of foundation.
Thank you very much, Your Honor. And those are the only two matters I had.
Okay, have a good rest of your day.
You as well.
Could the individual that's coming up as 360464, can you please identify yourself?
Yes, good afternoon. My name is Johnson De Jesus.
De Jesus, all right, good afternoon, Mr. De Jesus. Is this just a call in, so it's not Zoom? All right. All right, good afternoon, Mr. De Jesus. You're here on cause number 5A0728344. It's a infraction speeding 24 miles per hour over the speed limit. The matter's on for mitigation. You're calling in, your intent still to mitigate the case today?
Yes, Your Honor. I mean,
so the purpose
being that
go ahead. The purpose of a mitigation hearing is to explain the circumstances. You're not denying that the infraction was committed. You just want to explain the circumstances. I will let you know. Let me look at something here. Looks like was he eligible for deferral? Looks like he is.
I have a CDL. Last time I tried
you have
that.
CDL? Okay.
Yes, Your Honor.
Okay. All right, so, yeah, because if you have a CDL, you're not eligible for a deferral.
I was just like, maybe not too steep or maybe lessen
Let's see,
the,
say
the
that,
penalty.
say that again, Mr. DeJesus, sorry.
I was just wondering if I could just, lessen the penalty.
I got you. Okay. So I'm looking at your record. It doesn't look like, you have a ticket. It looks like you haven't, it's been a couple of years since you've had a ticket. What I'm willing to do in this case is so if we were to do a deferred finding, what is that? How does that get reported to DOL? Or is that like a continuance? Because deferred, okay.
Yeah, they call it deferred finding, but it's a deferred.
What if I wanted to put this out 6 months? Put on for review in 6 months, have Mr. McQueen or Mr. DeJesus pay $250 in costs. And if he doesn't have any moving violations in the next 6 months, it would be dismissed and he pays the $250. Can I do that? All right, Mr. DeJesus, what I'm going to do is this. I'm going to give you an opportunity here, okay?
Okay.
I'm going to continue your infraction for a period of 6 months. Okay? I'm going to have you pay the face value,
Okay.
$273. But if you
Yes.
pay the 273 and you don't have any moving violations in the next 6 months, the ticket would be dismissed.
I would get the 270 back.
Is that something you want to do? No, you would not get the 273 back. But it would keep your record.
I guess I could go on, and have a payment plan, but I'm more worried about the cost of the ticket.
I got you. Okay. All right. And what I can do is this, I can mitigate it down to 150 and it would just be found committed. But I reduce it from 273 down to 150.
Okay. Yeah.
Okay. All right. So that's what
Thank
I'll
you,
do.
Your Honor.
Yeah, you're welcome. I'll reduce it. You'll get a copy of this order and you can make payments on it, $25 a month. And so long as you do that, it doesn't get sent off to collections or anything like that. Yeah.
It'll be in my record.
Yep.
No problem.
Okay, 150 committed and just get the payments to the court.
Okay.
All right, that's all.
Thank you.
Thank you, Mr. DeJesus. Okay. All right. Good afternoon, Mr. Ellington. How are you?
Good, Your Honor. How are you?
Good. Do you want to do the Armento Zamaran case first?
Yeah, it's Zamaron, I think, but yes, it's 5A0864574. Thomas Ellington for the record. Your Honor, I did file with the court earlier today proof of insurance that was valid on the day she was driving this vehicle, proof that she has obtained a driver's license, but I have a 3.1B motion. I did receive video evidence, but there's no audio, and that's a 3.1 discovery violation under 3.1 that says the prosecutor shall provide all audio video that they have, and they reference it in the police report. So it's based on discovery violation. I'm moving to dismiss.
Okay, based on the above, I will go ahead and dismiss the infractions.
Thank you, Your Honor. And then I have one other case, and that is Lewis.
Okay.
And that's Austin Lewis, cause number 5A0760234. Thomas Ellington for the record. Your Honor, in this case, I'm moving to dismiss based on no police report narrative. I did receive discovery from the prosecutor's office, but the only thing they sent me was just a video, audio and video. I did receive discovery from the court on 11/24, which included the ADR, the face of the citation, explanations on hearings, but no narrative report. So I did not receive any narrative report from the prosecutors as required, nor did I even receive it from the court, which not sure that would satisfy the rules, but in any event, I don't have a narrative report. So moving to dismiss based on insufficient evidence.
Okay, hold on one second.
And the prosecutor's letter says, enclosed, please find the video discovery as requested for the above referenced matters. And that's dated December 1, 2025. The email from the court simply says, enclosed is a hearing notice and discovery. Doesn't identify what discovery was sent.
Let me just take a look. So I'm looking at the court records. So received letter, notice of appearance, request for continued hearing, demand for discovery, second request. Letter paid through. Okay, and our docket notes, so hearing notice and discovery emailed to Attorney Ellington. But you're saying you didn't get so you just got the ticket, which is page 1. You didn't get page 2 or 3?
That's correct. And I didn't get anything from the prosecutor's office, who is the required entity to send it. But I got the ADR from the court. I got the email from the court, mitigation contested hearing information sheet, and a copy of the court docket showing today's notice of hearing. That's the packet I got that I'm holding up.
Sorry, so you have a copy of the email we sent on November 24th.
Yes, right here. I'm looking at that. Yep. And it just, it says enclosed, please find the requested discovery, audio, video will be sent at a later date. Your Honor, I did print from Jabs directly myself, the report. And so I do have it if we need to get that far. And it's got deficiencies in it that I can go into if we need to, but I did not get it from the court or from the prosecutor.
So I guess I'm not sure we need to get into it, but I'm just into the actual, but I'm trying to figure out, because we have an email that we sent to what's the email we sent it to?
Tom@notguiltyagain.com. I received it 11/24 at 12:38 p.m.
Right, but what time? 12:38?
Yes, 12:38 p.m.
So the dilemma I have is the attachment that we have in the email that we sent is different than the attachment you received.
I received a total of 4 pages.
How many pages is our attachment? 12 pages.
Okay.
All right.
I don't know.
I'm gonna go ahead and dismiss the infractions, but we've got to just I know you, Mr. Ellington, and so that's one reason I'm gonna dismiss it, but I'm always I'm trying to figure out how come we would send an infraction of 12 pages, but only 4 came through. Is there something on our side or something on your side or whatever? I guess we just need to make sure we stay on top of that.
Yeah, no, I understand. If the email would have said, for example, attached, please find 12 pages of requested discovery.
Right.
Then I would have responded to the court saying, I only got 4 pages.
Yeah.
I mean, that's just an idea for the future to try to alleviate this type of problem. But I have a note here in the file that says I printed from Jabs, the police report, and I'll just share with the court for the record, there's proof issues. There was no post checks done on the radar, no pre-checks done on the radar. And the siren in the police report says he cycled it a couple of blips.
Yeah.
but never activated his siren as required by statute. So there would have been evidentiary issues also.
I agree. I agree. Okay, we'll go ahead and dismiss the infractions in the Austin Lewis matter as well.
Thank you, Your Honor. Have a good day.
You too. Bye-bye.
What day did you get?